matters. My lord remembers that on 15th of June, 19th of June, my lord has taken this matter of Anindo Shah versus Devashish Vishwas, and they were actually seeking that they have an appeal pending and they are about to actually deposit 10 lakhs of rupees in order to obtain that stay, but they have not yet deposited. My lord, on 19th,
Due to appeal.
my lord, on 19th June, my lord has passed an order that if they don't actually get an order of stay, then I will recover possession by way of a sheriff. My lord, that order is not yet been uploaded.
Is the matter due to appear?
Due to appear on 19th of July. 15th of July, my lord,
July.
but the order of 19th June, my lord, that is required to be communicated to the sheriff so that the sheriff may actually execute the decree and thereafter deliver me possession.
Chamber matter.
It's a chamber matter. The order is,
Has to be mentioned.
my lord, it's not yet been appearing. But the order is not yet been uploaded. That's why we are not.
Not yet been uploaded.
And
Which order? 19th June order.
yeah, 19th June order. 19th June.
Order
Yes,
is not
ma'am.
yet uploaded.
Yes, ma'am.
If the slip, it will be uploaded.
That we are unable to take appropriate steps. That's why we cannot take appropriate steps before the sheriff so that the sheriff can actually give us possession. We are for the decree holder. That is the problem. Please, your lordship.
Or mentioning in chamber application? Item number 1.
And for the petition version. Granted in 2014. Thereafter, certain defects were found. Defects has now been cured.
Which order you are relying upon?
Non-contentious, the grant of non-contentious from 2018 30 by Wakf.
Yes. Thereafter?
Thereafter, certain defects were found in the application document. Was not paid.
The matter by order dated 11th February, department was directed to witness the records and places under the heading. Yes. This is the 8th June.
There was deficit. And the brand new candidate could be granted in fees.
2nd July 2016, it was dismissed for non-prosecution. So, is this order recalled? 22nd July? Where is that order? Recalling this earlier order? 22nd July 2016.
There are 2018 non-contentious order.
No, maybe, but where is that?
This
Is that subsequent order recalling this earlier order? Before July?
2024 election. It's also there. Also granted lordship that it was granted on the month of May lordship. May this year.
Okay, 11th February for it. After 11th. department was directed to submit the report in order dated 11th February 2025. GA?
Yes, 7 is the file.
GA7 for no, here as per this report, it reflects the deficit court fees are paid. That is 21st August 2024.
Kindly accept this water project.
The deficit court fees are paid. Caveat certificate is issued when? May 2025. Here I am doing non-contentious. It will appear under the heading non-contentious.
Yes, Lordship. Because of the defects, Lordship.
Deficit court fees are already paid. Let it appear under the heading non-contentious. Even if it is non-contentious, you have to examine the attesting witnesses. Prove the witness. Yes, record an order. Learned advocate for the petitioner is present. As deficit court fees, terms of order 24 July 2024. And this matter is by order dated 6th December 2016. It is already been non-contentious. Let this matter appear under the heading of testamentary suit non-contentious. Non-contentious on when shall I keep it?
Yes, possible.
So when you can bring the witness? Appear on 16/7/2025.
In paper application matter, item what?
Let's execute the earlier order passed. Mr. Ali, your application is appearing.
But this is the last shot. Your Lordship.
No, whether your application is appearing,
It is
it
appearing.
has to be taken up.
K4. It is appearing.
I have filed as or every official in connection with the report, but he has not given reply till this.
Lordship, I have also filed an affidavit in opposition to my very senior friend's application, my lord. To that effect, my lord, he has filed his affidavit in reply also, my lord.
But I'll just indicate I'm appearing on behalf of one of the claims in GA10, my lord. Item number 8. GA10.
Not 5 to 11 application for addition of partition.
Yes, my lord. My lord, GA10 application has been served a long time ago, my lord. But my lord, no opposition has been filed, my lord. I have specific instructions on that.
Let me hear GA4, thereafter I shall consider the others.
Please. Your Lordship got this K4.
Before my lord here, my senior, Mr. Sardar Amjad Didi, my lord will kindly see by order and judgment dated 28 May 1989, passed by my lord Justice Ajit Sengupta, as his lordship then was.
Yes.
He was appointed for a period of 5 years.
Yes.
So after that, how he is continuing
This is a point to be discussed at first.
You have taken this plea in the
Yes,
opposition.
yes, I have
Yes.
already taken.
Should be
Because
taken.
we have said, because
Mentally.
all of a sudden notice has come upon us.
This application is being contested. You have taken that plea.
No,
in this
because
opposition.
we are not made a party. We have been only made only an order was passed to the officer in charge, Park Street Police Station and Gadiahat Police Station, take stock of all the properties, and there are tenants. We are under the Mutawalli. Mutawalli is also contesting, and my learned senior friend out of hibernation came up after 25 years to take the properties. I failed to understand what he was doing all that long.
But you are a party in this case.
Well, let him remember that has become the procedure. That even- even the petition.
The
Yes,
application is primarily against me.
yes.
So you have filed your opposition.
We have filed
Yes,
an
the opposition reply everything ready.
Lordship, the dispute mainly is
Mara should the applicant place
Yes.
his petition first.
Submit.
Should it be the
Because you have
procedure?
you have submitted your opposition. Let
We have
us see.
filed our opposition.
Yes.
On the
Yes.
ground of mentality, at
Okay.
first, whether he's.
Very well.
I've
My lord,
already
this is
stated
the
in my opposition.
My lord, may I, my lord?
Don't know the name. Appointed.
May I? One of these applications first came before my lord, Mr. Justice Sugoto Mojumdar on the 11th July 2023. That is the order. Lordship will kindly have a glance through this order.
It was the order passed on 11th July in your application.
Yes,
GA4.
GA4.
Yes. And what is the relief claimed in this application?
My lord, may I page the GA4 first?
This is
Because my
GA4.
learned friend said that Mr. Amjad Ali and the two other persons, we have no locus standi.
That will be considered after
No, no,
considering
no.
the objection
No,
and
no.
everything.
It has long been considered. My
Your
friend,
Lordship, I'm appearing for Mr. Amjad Ali on behalf of Mr. Suman Dutt. Suman
Yeah.
Kumar Dattu, sir.
with me.
Your Lordship,
Present party here, okay. So you are in person. You are a party.
He's a
Party
party.
applicant.
My lord, may I place my application?
Yes, yes.
The application will clear everything. Lordship kindly sees who are the applicants. It is not application, actually it should have been a report. One of the two persons, the other two persons beside Mr. Amjad Ali is one gentleman is a representing the board of Wakf, appointed by the court. And the other gentleman is there, representing the board of Wakf, the Wakf,
Yes.
appointed by this honorable court. That forms the committee of management. Now the committee of management has been framed by this honorable court. Why? Lordship will kindly see. This is relating to suit number 1444 of 1942 and suit number 1488 of 1942. These are the two suits. Your Lordship got, my lord, that these are the applications.
Yes.
Humble application of the committee of management appointed by this honorable court for administration of Mokim Sarkar Wakf estate. Why? It is a Wakf estate. Now, my lord, I am placing my application.
Yes.
Applicants take out this application considering an extreme urgency that has arisen in the process of administration of the public Wakf. Mokim Sarkar Wakf estate, the state comprising of number of valuable properties in the city of Calcutta that was involved in the aforesaid two suits. decreed with a scheme framed by this honorable court. These two seats were decreed. The applicants, having been appointed as Committee of the Management of Administration of the Wakf, considered to take appropriate direction to face the difficulties and or inconveniences of administration. 1. By a decree dated 31st August 1944, in the above consolidated suit, a scheme was framed for the administration of a public work under the direct management of this honorable court. A scheme, a list of properties of the said work as provided, my lord, it is there. Your lordship will kindly see at Annexure A at page 10. At page 10. Lordship sees 17 Guriahat Road, 1. 17 Guriahat Road, a very valuable property.
Page 10, Annexure A, 17 Godiya.
Annexure A, yes.
Yes,
71 and 73 Elliott Road.
yes.
Then 77, 78, 79, 80, 82, 82, 8 by 2 Collins Street. 52 Free School Street. This is by whom? Well, this is by the Commissioner of Wakf, written to Mr. Amjad Ali. In response to my letter, dated 10th of July 1987, a list of properties relating to Mukim Sarkar are furnished below for your information. What is the authority of Mr. Amjad Ali to write to the Commissioner of Wakf? My lord, yes, my learned friend has given that clue. That Mr. Amjad Ali at one point of time, Mr. Amjad Ali, at one point of time was appointed as a special officer of this particular Wakf estate by Justice Ajit Kumar Sengupta. My learned friend is correct. But my learned friend ought to have made his brief, or I'd go through the papers and the orders passed from time to time by this honorable court. And he should have come to know as to what is the status of this committee now, without making an allegation that these fellows, Lordship will kindly pardon me using the word fellows, that they do not have any status to appear before this court. Then, by a decree dated 31st August in the above consolidated scheme, a scheme was framed for administration of public work Mukim Sarkar under the direct management of this honorable court. But the entire Wakf estate is now under the management of this honorable court. A list of properties, a synopsis of the said suit as appears from an order dated 29/2 made in the said suit by His Lordship the late Justice Malik, and a copy of the scheme are annexed as application Annexure B and C. Lordship kindly goes to Annexure B at page 11. No, he cannot interrupt. Yes.
Annexure D.
Yes. My lord, I do not want to shout, my lord. I do not. Your lordship will kindly pardon me, but I do not want an interruption.
Yes.
Let
17,
there be
page 17.
process. Yes. A public web created by Mukim Sarkar by 3 work deeds.
Page 17.
Page 11.
Page 11. Yes.
Page 11. By 3 deeds, a public work was created. Then 2. Litigation started in 1929 with suit number 92 to set aside a lease granted by the then Matwalli. Lordship kindly marks it. Matwalli is appointed by whom, my lord? Matwalli is appointed by the Board of Work. Board of Work granted the lease. It was a lease granted by the Matwalli. It must have been either within the knowledge or without the knowledge of the Board of Work.
Yes.
Certainly. And what happened? Well, from court record, I shall say. I shall prove it before your lordship that it was the Board of Work, my lord. They were charged for misfeasance. They were charged for misfeasance, for which, my lord, the court has to take up the entire administration under its own administration. Subsequently, suit number 4 and 92 was started. Both suits were consolidated and decree was passed on 31/8/84, framed a scheme for management of the work. The acting Matwalli Nazir Hussain having retired, the scheme provided for appointment of Khadem Hussain as Matwalli. Future Matwalli were to be appointed by the judge in chamber Lordship kindly marks this. Future appointed, yes. Two Najis, Maulvi, Abul Khair and Azizul Islam advocates were appointed. The last clause in the scheme read as follows. There is a general liberty to apply, and all matters arising out of relating to the scheme shall be dealt with by the chamber, by the judge in chamber. There were various allegations against the Matwali. When in an administration suit, the court frames a scheme in the final decree and liberty to apply is reserved, the suit is not altogether dead. For the limited purpose of giving effect to the scheme, the suit is pending.
That means that scheme was not challenged, decree was not challenged, so that
No.
is binding.
No.
That has reached its finality.
Yes.
Anyway, that is binding.
Yes. And then, my lord, for limited, what is the status of this suit now? For limited purpose of giving effect to the scheme, the suit is pending, even though it has come to an end by passing of a final decree. For a limited purpose, the Commissioner of Wakf has no power. Kindly see, my lord. This is not my word. This is the word of the court, a judgment. The Commissioner of Wakf has no power to vary the scheme, but the Commissioner has the right, whenever necessary, to rise before the court for appropriate order. Now, your lordship gets at page 13. The total scheme is there. Schedule A refer to the annex decree made in suit number 1 so and so. This particular final scheme, by an order, page 13. By an order of this court, my lord, the earlier court, my lord, your lordship's coordinate bench, my lord, the scheme was given to everybody.
Yes.
This scheme from the court record.
This clause 7 is there is general liberty to apply and all matters arising out of.
Yes.
To this scheme.
Clause 8. Clause 8 you have seen, my lord.
This 7.
Yes. Clause 7. Your lordship. So this scheme is there. Now, my lordship goes back. Your lordship goes back to page 3 of the application, my application. Why this application? A status report of the Wakf is annexed here with as Annexure D. Lordship kindly goes to Annexure D. At page 17. Yes. The Committee of Management appointed by this Honorable Court is presently running the administration of the state in respect of 7173 Elliott Road, 17 Godiya Road, 17 Collins Street, 52 now 31 Mirza Ghalib Street, by collecting rents from the tenants inducted in the respective premises since long. All collections made from the rent and contributions are deposited after necessary administrative expenses and remuneration of the committee members as directed by the Honorable Court in Savings Bank account number so and so in the United Bank of India, now Punjab National Bank, Kolkata. A fixed deposit in account number so and so, 12,29,400 rupees, is also lying with the said bank. My lord, when Mr. Amjad Ali took over the management, my lord, the rent receipt had to be printed at his own expenses.
Each year, 85.
Yes, that was the 87. And my lord, the rent receipt had to be printed at my own expenses. No money, not even 1 rupee. And the entire property was under the occupation of the occupiers. And the Board of Wakf was there. Now, my lord, the committee submits audited statements and accounts regularly in proper to Board of Wakf. Now, my lord, Annexure E will lordship will know what is the my lord, the headache of this committee. Premises number 77 and 78 Collins Street. My learned friend is represented. Mr. Abdul Rashid, a resident of 82 Fias Lane, Kolkata, claiming to be landlord and collecting money as rent from the occupiers of the said premises. Since takeover of the management and administration, erstwhile receiver and thereafter committee of the management, the physical possession of the aforesaid premises could not be taken due to various fake claims and counterclaims. But as per order of this honorable, symbolic possession was taken. 77 and 78. Then Lordship goes to Annexure E. My learned friends, all of them have come, my lord. And all of them have been served. Premises number 82/2. Mr. Haji Mohammad Jangir 71. Mr. Haji Mohammad Jangir is
The
representing
present applicants have been served according to.
everybody.
Okay.
And my lord, all of them,
So served what? Notice.
yes. Now, my lord,
We have been served with an application.
This application was
Every-
served upon all the occupants there.
yes.
Orders have been sought for against me. I have filed my affidavit.
The order is sought for against.
My lord, you will hear him.
That is there. But the question is,
My lord,
service has been effected upon all the occupants.
all the occupants.
And though they have come before this court
Yes.
to be added.
Yes. 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 I will answer to him.
And if
I'll
you have filed an application,
Who is he? Let me see. Let me know who is he.
he has an applicant before this
My
court.
lord, I know who he. Who? By name, he must say that he is appearing for whom.
Unless you deal with his application, you cannot.
Yes,
contest.
my lord.
You have to deal with his application.
My lord. So at the time, my lord, when his application is being dealt with, who is he? Who is he? Yes, my lord, they have no locus standi, I have shown it. Under this scheme? Under this scheme?
Anyway, for that you have come out with an application.
Yes, with an application.
Yes.
And my lord, when his application comes, I shall reply to him. But I have shown, my lord, the gentleman, my lord, appointed by this honorable court upon a recommendation of the Board of Wakf, representing the Board of Wakf. So, my lord, this is my application. In this application, my lord, there are other people. This. Now, my lord, your lordship will kindly take up this. In the list, your lordship finds my application is serial number 2. Is serial number 2.
Yes, I am dealing with your application, GA4.
My application, GA4.
Your application.
So, my lord, this is my GA4. In the GA4, my lord, there is a status report. That GA status report also I have referred to your lordship.
Status report is in which page?
My lord, status report, yes. After the first order, it was filed, my lord, on the 9th August 2023. That is the first order, my lord.
Yes, there was a direction to serve copy of this
Status report
application
and
upon,
record.
upon the claimants mentioned in Annexure E and F.
Yes,
That direction was there.
not actually and F.
Yes. That was done.
That was done.
Now, thereafter this matter was directed to appear for further orders.
Yes. That is the first order, my lord. Thereafter, many orders have been passed, my lord. Or that is the first order. My lord. That is the only copy, my lord, I have it. Play, all right, let it be there. I'll take it up, my lord, and then. So now your lordship takes up. So my application appears GA4 is item number 2. Yes. Then there is one GA5. Your lordship can you find this GA5 item number 3.
Your application, GA5?
No. My lord, all these matters thereafter.
Yes.
My lord, after GA4 was filed,
These applications were filed subsequently.
these applications were subsequently filed. My lord, these are the offshoots of GA4.
GA5 and GA5 to
Not
GA10.
only GA5, GA5 to GA9.
GA10,
10 and 11 are separate. 10 and 11 are separate. Yes,
And with regard to that annexure E and F, you are directed to serve copy of this application.
yes. So, my lord, GA2, my lord, these are the next are, my lord, 5 to 9.
Yes.
These are all, my lord, subsequent to GA4. That means all these have to be taken up together. Who are they? My lord, these are the, according to the committee, my lord, that they are the occupiers.
Who is opposing this application? GA4, you are opposing.
No, everybody is opposing.
No, no.
GA5, GA6, GA7, GA8,
First of all, they have to be added as a party. Then only
they
can-
cannot be added.
Anyway, then no question of opposing this application.
No, they cannot be added.
First of all,
I shall place the order. It is the reporter. My learned friend has placed.
Yes. Okay, you have made your submission now. Let him.
No, my submission is
GA4. I'm just
on
dealing with
GA4.
Yes.
On GA4. My lord, therefore, what I want to say,
11 July, after 11 July, what is the order passed? Let us see.
there are so many orders.
Give a compilation of those orders. Give a compilation of the orders passed after 11 July 2023.
I have within it that.
Order sheet file also.
আছে আমার আছে তো
In August, the status report was filed. Entered your appearance on 10th August 2023, probably. As it is observed that some of the documents have appeared. So you have appeared here after that. ENF that there was a direction.
Somebody else is perhaps appearing. I am appearing only for you. My number 77 and 78 for you. Page 18 of the application.
Page 19.
18, my lord.
18.
I appear on behalf of Mr. Abdul Rashid.
Yes.
Because there was a direction to say service upon the occupants with regard to annexure E and F. So necessary service was caused, and you are representing the occupants as mentioned in annexure E.
Yes.
That is 77, 78 Collins Street.
It's 10th August. And there was a direction, I think,
No,
regularly with
in annexure E, there is another premises
this annexure.
at page 19.
Page 18.
At 19 also there is another one.
Page 19 is annexure
88
F.
by 2 Collins Street.
Not appearing for
Annexure F, that is annexure F. That is
No, annexure E.
E
Annex-
is appearing. Your learned friend is appearing. E.
My lord, there are
Abdul
two
Rashid.
pages. There are 2 pages. 18.
I am not appearing for the occupiers of 88 by 2 Collins Street.
So far page 18 is concerned.
I am appearing
Annexure
for
E, you are appearing.
Yes. But my lord, annexure E is relating to 77, 78 Collins Street.
Yes, that is there. Your learned friend is
He
appearing.
is appearing.
Now, who is appearing with regard to premises number 88 by 2 Collins Street?
Yes.
That is for Mr. Haji Muhammad Jahangir and Mr. Ishrat Usmani. Anybody is appearing? So nobody is appearing.
Well, let it be recorded, my lord.
Because you are appearing with regard to 77 and 78. Very well. So, 29th September.
Your Lordship, I just want to say that, I just want to place that I am appearing for the specially assigned officer, Mr. Amjad Ali. And Mr. Suman Kumar Datto is my senior in this matter. I'm leading him in this matter, Your Lordship.
It's better you appear physically, otherwise it becomes very inconvenient. You try
Your
to
Lordship, yes, Your Lordship, I'm I'm just coming. I was on my legs in some other court, Your Lordship. I'm just coming to Your Lordship's court. I beg your pardon, Your Lordship.
No, please come.
I beg. Yes, Your Lordship.
Very difficult.
Hey,
স্যার আপনাকে রিপ্রেজেন্ট করতে
আমাকে represent. No, I understand. My lord, of the state, my lord,
Yes.
Mr. Suman, they will appear. She is his junior. Make it clear.
Mr. Suman Datto. Suman Kumar Datto, Your Lordship. Not Suman Dev.
Yes, I understand.
Yes, yes.
Suman Datto,
It's better.
representing
better
the
he come
state.
and he comes and appear physically.
Don't worry, I have stated that. Yes, Mr. Datto told me also.
So let him come and appear physically.
Yes.
Your Lordship, my instructions were to take an adjournment today, but Your Lordship, since I was not in time to reach Your Lordship's court, therefore I could not plead from online to plead for an adjournment today, Your Lordship.
He
I
is
beg your pardon, Your Lordship.
for committee. He is appearing for the state. Now it is my application. 3 persons, they are there.
29th September was also an order
Yes.
directing you to disclose some documents regarding the address of your client.
What good did he?
October 2023. Thereafter, there was a direction to file affidavits, to which you have filed.
He has filed the affidavit.
Is also filed on behalf of the intervener in respect of GA4. Yes, who is representing Wakf board? Mr. Najmal Hussain, Mr. Syed Najmal Hussain. You are representing. So, you are also granted opportunity to file the affidavit.
And G11 Dhorini Baba, G4.
So, in GA4, you were granted opportunity to intervene and file your affidavit. So, was that done? In GA4, you have filed that.
Yeah, G4 file. Yes.
Oh, very sorry, Your Lordship.
Yes.
Very sorry, sir.
Thank
There
you very
was a
much.
direction to serve the copy of the decree upon the councils. Was that done? Have you received the copies of the orders?
Yes.
March 2024, there was a direction upon the register in charge ordinance, right? To submit copy of the order dated 31st August 1944. That is the scheme to the parties,
This scheme has been served to all.
for all the parties.
Yes. To all the parties.
One second, just address the court and inform him that I'm
About what? I have told it. I have told it. Said about it, Baba. Yes. My lord, dear
Lordship, appearing on behalf of the specially assigned officer, Mr. Amjad Ali, Mr. Suman Kumar Datto is leading me.
Preparing for Mr. Ali.
Yes, Your
Who
Lordship.
is leading you?
Mr. Suman Kumar Datto.
So what do you want today?
Your Lordship, my instructions were,
He's appearing in person.
No.
no, my instructions today were,
All you want Mr. Datta to address.
Mohan Datta is not appearing for Mr. Raj.
no, Your Lordship, he is. He had a word with Mr. Early yesterday in the morning. No, Your Lordship, I've received instructions from my senior directly. Your Lordship, we were in the last minute informed to appear, but since my senior is on his legs in some other court, Your Lordship, my senior had asked me to ask for seek an adjournment today, Your Lordship. But since I failed to appear on time to seek an adjournment, Your Lordship, I appeared online. But
He's appearing himself.
I can adjourn you. That is no problem. I'll always grant a reasonable opportunity.
Lordship, a client is appearing in person. She's appearing on.
Maybe there is some miscommunication.
because I received instructions last minute, Your Lordship, I'm just acting on the instructions I received. Maybe the client is appearing in person, but I'm acting on the
The
instructions
client
that
is
I've.
standing next to you.
Do you know your client?
No, Your Lordship, I've never met my client.
Your
Your
client
Lordship.
is standing next to you.
Very well, very well. I understood. I heard you twice. But Your Lordship, I've never met my client. I've just received instructions from him, Your Lordship.
I don't want to engage. Okay.
Then
I don't want to engage. I recall.
you should accept a power and then file.
Yes.
If you want, you have to accept, you have to take a power and file it. Because Mr. Datta is a senior counsel,
Yes, Your
so
Lordship.
he cannot accept the power. So if you want to appear,
Kindly read
you
it.
have to accept.
Kindly read it.
So you have to accept a power from Mr. Ali.
Kindly read it.
Okay, and you file your Vokalatnama.
Your Lordship, I do not file a wakalatnama, Your Lordship, and I'm not asking.
Unless you file a Vokalatnama, you cannot claim yourself to be the advocate of a particular person or committee or whatever it is. So if you want on the next day, you can file your Vokalatnama and appear.
I apologize for the disruption that I've caused, Your Lordship.
Just
I beg your pardon.
anyway,
Your Lordship.
after the court is over, you seek clarification on all these matters and do the needful.
I apologize, Your Lordship. I beg your pardon.
So, my lord, your lordship's query was, my lord, as to whether the scheme has been delivered to everybody else.
Yes, that was the direction.
It was. It was delivered.
Lordship, I have received a copy of it.
Yes, everyone has got it. It's not my interest, my lord. I am representing the interest of the court.
Some of the applicants have appeared and have filed the affidavits. Yes, in terms of 5th March 2024. Order along with the scheme to the parties in terms of the previous order. Anyway, on the next day, there will be the department will issue.
My lord, the question is, many applications are there.
All these applications are to be heard out and they have to be supplied with the order, the scheme.
No, my lord, my learned friend's case is,
Yes.
my learned friend's case is that the department has written to him that first you get admitted as a party and then I shall give you. কি দিয়েছ ওটা দাও না আমাদের একটা কপি দাও আগে ও পড়ে আসুক যে পার্টি অ্যাড হওয়া যায় কিনা এতে শুট হুইচ হ্যাজ বিন ডিক্রিড তাতে পার্টি অ্যাড হওয়া যায় কিনা তাই না
The department has clarified that no decree or order was passed on that date, that is on the date when Justice Mojumdar passed the order, that is 2024. Judgment was passed on the date 31/8/1944. And the same is available with the suit bundle. That is the clarification of the department. So far you are concerned, you have already
Lordship,
obtained.
the court had already directed, copies were made and distributed to whoever was appearing on that date.
So you have received,
We have received.
you have also received. Yes, yes, that is there definitely.
Try to learn the court balance. Try to learn the
Anyway, so they were granted all were the intervening applicants for interveners were granted opportunity to file their affidavits.
Yes.
So you have also filed your affidavits. Yes. Yes.
There are other applications. So far as my learned friends, that is the E and F. E. Your lordship was fine.
Applications means what? I am now considering this application. If there are other applications for addition of parties, let them place their applications. So far you are concerned, I am considering GA4.
Yes, it's GA4. GA4. But GA4, my lord, the other applications,
Yes.
what I want to incidentally point out,
Yes.
there are GA5, 6, 7, 8, and 9.
Yes.
GA5, 6, 7, 8, and 9.
Yes.
These applications, my lord, have been made.
Yes.
These applications have been made by some person asking for addition as a party. What is their status in the application? In the application, they say that my learned friend, she has inducted them as stated.
Very well. That
Yes.
will be considered.
So my
whether-
my learned friend has inducted them as tenant.
I have not taken up this either 5, 6, 7, 8.
Yes, therefore
Right.
GA4, my lord,
Yes.
GA4 has to be hard together with 5, 6, 7, 8, and 9. 11 and 12 are separate applications.
Yes.
Separate application.
Your application is appearing in the list. Very well. If it is appearing in the list, definitely it will be taken up.
So, my lord, GA 5, 6, 7, 5, 6, 7, 8, and 9.
Let him submit with regard to your application. GA4.
Grateful, Your Lordship. Your Lordship will kindly take the prayers made in the application. Lordship will find the prayers at page 5. Your Lordship will find appropriate notices that
Well, my learned friend
has
has
been
given an
served.
affidavit.
prohibiting
given an
each one of the persons from collecting money from the residents in respective premises as in list E till final adjudication of the claim by this honorable in the event of non-compliance of this order. So this,
So this is prayer A.
Lordship, prayer is appropriate notices to be served upon the unauthorized occupants in list F. I am not in list F, I am in list E. Through local police station, asking each one of them to be personally present. So I am not concerned with prayer A, my lord. As far as prayer B is concerned, I am concerned with that, prohibiting each one of the persons from collecting money from the residents in the respective premises as in list E. This is where I am concerned because I am a part of list E. In the event of non-compliance with orders conduct, final adjudication of their claim, that prayer C not being satisfactorily proved as in B above, not to interfere with the administration of said premises. Lordship, pausing here for a moment, kindly take the grounds for this prayers. The grounds are at page 4, paragraph 3. The committee is facing serious interference in the smooth and proper administration and management of the Wakf due to unauthorized occupation, undue and illegal interference, collection of money on fake claims of legal rights by impostors from some of the valuable premises of the Wakf. As a result, the Wakf suffers from financial losses and it becomes a serious challenge for the administration of the Wakf. Persons involved in such fake claims of ownership and collection of money have been narrated in the status report marked as Annexure E. Lordship, Annexure E is page 18. Lordship will read the heading Fake Claims of Ownership and Collection of Money from premises number 77 and 78 Collins Street, PS Park Street, Kolkata 16. Mr. Abdul Rashid, a resident of 82 Fierce Lane, Kolkata 12, claiming to be the landlord and collecting money as rent from the occupiers of the said premises. So the allegation against me is I am making fake claims and collecting rent from these two premises. Your Lordship,
77 and 78.
yes, my Lord.
For opposition, what have you stated?
Lordship, we have disclosed registered documents where the court confirms transfer in our favor. Yes, my Lord. Your Lordship will kindly take our affidavit. Will kindly start with page 14 of the affidavit in opposition.
Yes. Page 14.
Yes, my Lord. Is it a legible copy of the affidavit in opposition, my Lord?
No.
Yeah.
Hassan Ali.
Abdul Rashid. Yes.
Okay.
I'm sorry, my Lord. It is affidavit. Affidavit. AO.
Rashid Ahmed.
I'm sorry, my Lord. It is not very legible, I believe. Your Lordship will find it's a document dated 9th December 1921. It is a registered lease from the then Mutawali. Your Lordship will find Muhammad Ibrahim. The Mutawali had given it to Muhammad Ibrahim for 99 years. Your Lordship will find the names. Your Lordship will find the fourth line, the last word. It's from the Mutawali. Your Lordship, can Your Lordship read the document?
Muhammad Ibrahim,
Yes.
son of so and so.
Yes, my Lord. Muhammad Ibrahim, son of the Mutawali. Mutawali of the trust. Muhammad Moin Mukim. Lordship, it is.
Yes.
To Muhammad Ibrahim. Lordship, I will not trouble your Lordship because this is just the first document. There were many registered documents thereafter. Your Lordship will kindly take, if your Lordship kindly takes over to the next page, page 15, just before now this indenture witness.
Yes.
An order was made. Your Lordship will find about 5 lines above now this indenture witness. November 1925, an order was made by the Honorable High Court in its ordinary original civil jurisdiction, granting permission to the lessors, which is the Mutawali, to demise
So
the
now this witness just below.
Lordship just above. Lordship 5 lines above that. An order was made. Has your Lordship got it?
Page
5
50.
lines from the bottom.
No, Lordship. Now this indenture
Page
witnesses.
15. Page 15.
Yes, my Lord. Now this indenture witnesses. Has your Lordship got?
Yeah.
Lordship, it should be in the middle of the page.
Yes, yes. Now this witness, indenture witness.
Just take 5 lines, your Lordship, above that.
Yes, and whereas on the petition of the lesser.
On the lessors, as such, allotments as aforesaid on the 30th day of November 1921, an order was made by the Honorable High Court in its ordinary original civil jurisdiction, granting permission to the lessor, this is the Mutawali, to demise the said premise number 77 and 78 Collins Street, Calcutta, to the lessee in terms and conditions mentioned in the said order, and also hereinafter contained. Your Lordship will find that this is pursuant to an order of court. Will kindly turn over the page to page 16. Lordship, third line from the top. All those piece and parcel of land being premise number 77, 78 Collins Street and the premises number 77 containing an area of, Lordship, the description is given. Lordship will kindly come till to hold. This is the property being given. Has your Lordship got to hold? To hold the said premises for a term of 99 years to be completed from the 1st day of January, yielding and paying, therefore, during the said term, a monthly rent of ₹50. So it's a registered lease confirmed by an order of the Honorable High Court. This is my induction, starting of my induction into the property. Your Lordship will kindly take, I will not trouble your Lordship with the rest of the document, will kindly come to the next document. Your Lordship will find it's a document dated 8th April 1922.
That is page.
Lordship, page 21. Lordship will perhaps have to open it. It's a longish document.
You are Rashid Ahmad, na? The document says something else.
Your Lordship will find this is a document, registered document dated 8 April 1922.
April 19 years, 1922.
Yes, my lord, where Muhammad Ibrahim, the original lessee, as your Lordship saw in the last document, assigns the residual period of the lease dated 9/12/1921 in favor of Muhammad Akbar. This is also a registered deed. Your Lordship, this is a.
It is 99 years from.
Yes, my lord, 99 years.
Page what?
99 years.
Page 21.
21, sir.
Page 21.
Sheikh Muhammad Ibrahim, son of Muhammad, owner, and Sheikh Muhammad Akbar. So it goes to Muhammad Akbar. Your Lordship has got it?
Yes.
7 lines from the top. So this is the first assignment. I will not trouble your Lordship with the rest of the document. It's again assignment of the residual period. We'll kindly take the third.
By the Matwali.
No, Lordship. The Matwali had given it for 99 years pursuant to orders of court.
Yes.
This is the first assignment of the lease for the residual period.
That means by the lessee.
By the lessee under the original deed.
Yes.
Yes.
Original lessee was assigned this right.
Assigned it in favor of another person. Your Lordship will come to page 25 thereafter. Your Lordship will kindly. It's the next document, Your Lordship.
Okay, 25.
I'm sorry, my lord. This is just old document, so it's very big.
Five.
Yes, my lord. Page 25.
27 is this another indenture.
Lordship 25, page 25 it would be.
Page 25.
It is up to 24. That means wrongly paginated. 25 and 26 is missing. 27, I have 27. You are relying upon this indenture. 12.
Lordship, it's a sales certificate issued by court. Page
is
25.
Anyway, that is anyway either wrongly paginated or missing. This is assignment of lease.
No, my lord, it's not assignment.
So this is by the registrar. Office of the registrar.
Yes, my lord, it should be by the office of the registrar. It's a deed. It's a deed, Lordship.
Page 24.
Lordship, it should be the page just before that.
23. Okay, this is delivered, signed, sealed, and delivered. This deed of assignment.
I believe it's not there.
To file a supplementary affidavit, then disregard. Okay. Yes.
Sorry, because it should have been there. It's Calcutta kind of filing here again, Injera.
Again. 4.
Lordship, may I just have a look at this? Have a look at the certificate.
The applicant in GA4 of 2023 is present. Our learned counsel for the applicant. Peruse the petition file. As during the course of the argument of GA4 of 2023 submitted by.
I'm sorry, my lord, it is there.
Okay. It is there.
I'm so sorry, my lord. It has been wrongly paginated.
Get it. Get. Okay, this is the.
Then order of court sale.
It is stitched. This entire copy, I cannot get it. It's better if file a supplementary.
Yes, my lord, I shall file.
During the course of arguments, as one of the documents not properly annexed in the record, the intervener,
I'm sorry.
the intervener in this case, that is Rashid Ahmed, is granted an opportunity to file a supplementary affidavit on or before 4/7/2025 upon service of copy to all the parties. Let this matter appear on 15/7/2025. Learned counsels appearing in GA4 of 2023 are requested to come with written notes of arguments on the said date.
And if necessary, one will reply to that. The supplementary.
A reply may be filed.
Sir, only for addition of documents.
Anyway, a reply may be filed with regard to the supplementary affidavit.
Yes.
Only GA4. Let the other applications appear along with
One
GA4 of 2023.
Yes. Only one thing. Is my GA4.
Yes.
GA4.
GA4?
GA4 at page 21.
Page 21.
Page 21.
Yes.
These are the people, my lord, in 70 of unauthorized.
Them notice have been served.
Notice all have been served and they have also approved the committee. And by approaching.
Anyway, they are not before this court, so no question of adding them as a party.
No, they have, because there was a liberty given to the committee.
Yes.
That they can approach the committee.
Yes.
So pursuant to that, they have approved.
Yes.
And all of them, my lord, they want to be inducted as tenant of the state.
See, but
They agreed.
But they have not come up before this court, so no orders can be passed with regard to them. Whoever has come before this court, the court has to consider.
They have to appear.
Yes, unless they appear and praise for addition of party, how the court can appear.
We shall instruct them.
Anyway.
Let you appear.
I have your lordship's leave.
Yes, yes, thank you. Yes, 15.
Because these unauthorized documents, my lord, for years together, they are in a.
Nobody can be evicted without due process of law.
You know,
That
that's
is the
right.
well settled principle.
Question of not eviction.
Yes. Whatever you want to evict anybody X, Y, Z.
I am not asking for eviction.
Yes.
They say that we are ready to be tenant of the Wakf.
So that we have to consider the scheme. You have to consider the Wakf Act and thereafter decide in accordance with law. Yes. Yes, but the Wakf Act is to apply. Both the scheme and the Wakf Act.
The scheme will apply. It is the scheme.
Yes, that is there, but subsequently that there is a statute.
I don't know whether the Wakf Act is there. Still.
Yes, it is.
Is it there?
Yes. If it is there, it is binding upon all of us.
I guess it is
No.
because of that.
If it is there,
If it is binding upon all of us, we have to accept.
that's right. That's right.
Yes.
But when the state is under the management of the code, section 92 of the Civil Procedure Code.
That scheme has to be considered before taking any
Yes,
decision.
it is the scheme. It is the scheme.
Whether it was renewed, how it was, the tenure was extended thereafter, everything has to be done.
And it is my learned friend, it is the Wakf board. It is the
Whether it is a scheme, whether Wakf Act, it's a well settled principle of law. Nobody can be evicted without due process of law.
question of eviction is not there.
Unlawful claim cannot be justified. That is your stand.
That is my state. And unauthorized persons cannot. If they agree that yes, we want to be inducted as a tenant of the Wakf, as a tenant of the state, well, a direction should be given.
Yes.
The board will take decision.
Board has nothing to do.
Yes, lot of.
It is the order is there
Anyway, your application
under
is
the
there.
scheme.
Yes, scheme that is modified. Scheme will be modified.
Under this scheme,
Your application is there.
it
when the
cannot be
matter will
modified.
decided.
Read the law. Read the law. Very good. If it can be modified, it will be modified.
It will be modified.
First of all, your
Nothing to do.
application for addition of party and thereafter your other claims.
The court will decide.
And my lord, I shall be placing before your lordship the judgment of this court, wherein it has been recorded the malfeasance and misfeasance created by the Board of War, for
But that-
which
has
it
been
was
amended
taken, under the management of the court by Justice Malik.
That will be considered.
Why the scheme was framed, why everything was brought in.
Anyway,
Has to just-
still that is until that is
Lordship,
modified or varied, that is binding.
Lordship,
Which may not be.
Keep it with you. File it when that matter will be taken up.
Number 11 and
No. When that matter will be taken up for hearing, you file it. Otherwise there will be confusion.
I am taking back the past order that I have given.
Yes.
Item number 11.
11.
Item number 11.
Yes, 11. Yes.
Perhaps we come back to your lordship. My regard to my lord, Maharaja of let's say in Gujarat, there's a huge property, and which is the position of the government of India. And my lord, the last occasion, and that property is sort of say all the my lord the benefits.
We're appearing for the administrators.
I am appearing for some of the beneficiaries.
Some of the beneficiaries.
Representative of the special officer who is in possession of the property. You are kindly come to page 108. I shall take your option for a application. Perhaps I will not be able to press. I shall ask for some of the prayer. Kindly come to 108. This is your lordship last.
Yes. This matter was moved
Yes, kindly
earlier.
Kindly see your lordship's order. But learned advocate, it appears the learned special officer in this matter has sought for leave from this court to file appropriate application for the commission and delivery of position. Thus, necessary granted to file the application. Matter may be mentioned by the petitioner upon necessary applications being filed. So, my lord, this application has been filed, but frankly speaking, my lord, such application is not maintainable in law. I cannot, my lord, ask for the prayer which has been asked for. Kindly come to prayer A at page 16. So what I shall ask for modification of the
Yes,
prayer
16.
page, your lordship, page 16 of the petition.
Page 16, yes.
Kindly see the prayer.
Direction may be given.
Yes. Determination of the contractual agreement lease dates executed in the parties, so and so. Direction may be given to respond delivery of peaceful. But that cannot be done. If it since it's a long lease, it's so
Does the court determine the lease? Okay,
court cannot.
under
My lord,
the
I cannot. My lord,
Property Act, that will apply.
absolutely. My lord, what I am submitting to your lordship,
This suit, how the court can
the court cannot. So, my lord, may I submit this? Your lordship, on this application, your lordship will kindly direct my lord, the special officer, to hold a meeting of the parties. Take decision with regard to determination of the lease, because notice the forfeiture will of lease under section 111 will have to be given of the Transfer of Property Act. Then my lord, a suit has to be filed.
What is it? Because you see, what is the grievance against the lessee? Suppose the lease is given, but there must be some grievance against the lessee.
No rent is being paid at all. Decree has been passed for payment of rent. Even then, my lord, they preferred an appeal. Appeal has been dismissed. In spite of it,
And as you know very well, that nobody can be evicted with the due process.
No, absolutely. That is exactly what I'm saying, my lord. That is why I am submitting to your lordship, my lord. My lord, with a clear conscience, I cannot ask for these prayers. So, my lord, what I am submitting to your lordship, my lord, kindly pass an order directing the special officer, because your lordship, so my lord, has the jurisdiction on the special officer, to hold a meeting of the parties, to issue a notice of forfeiture, and my lord, to take necessary steps for eviction. Kindly, my lord, pass that order on this application. I will not, my lord, press for the orders which have been asked, which has been asked.
106
You're for the beneficiaries.
Yes, my lord. I am for my lord. The beneficiaries, kindly see There are 4 of them. They are, my lord, not the only beneficiary. There are other beneficiaries who are receiving the money from time to time.
Some of
So,
the beneficiaries.
Yes, some of the beneficiaries. I am appearing for respondent, appellant number,
Committee of Management.
Committee of Management. Committee of Management consisting of petitioner number 1, 2, 3, and my lord, the special officer. Well, kindly direct, my lord, the
That is the appellant, that is Sundari
Sundari
Devi,
Devi.
yes, Kamashundari Devi and
Rajeshwar Singh.
Rajeshwar Singh and Kapileshwar.
Kapileshwar Singh.
They are, my lord, the Maharaj Kumars. And my lord,
the
Kamashundari.
beneficiaries of the estate.
Yes, my
Of
lord.
this,
Committee of Management.
of Maharaja Kameshwar Singh.
And also, my lord, in the members of the Committee of Management.
And
এরকম
members of
application
the
হয় না।
Committee for Management. Where is that? Members of the committee?
Committee of Management.
My lord,
Humble petition.
yes, Committee of Management.
Sundari Devi.
After appellant number 3, sorry, petition number 3,
Rajeshwar Singh.
Kapileshwar Singh. After that, all the members of the Committee of Management is represented by Ashutosh
So
Datta
here you see humble petition on behalf of Sundari Devi, Rajeshwar Singh.
and Kapileshwar Singh. Kindly turn over the page.
Page 4.
Yes, page 3. Page 3.
Page 3.
Kapileshwar Singh, and after that, kindly see all the members of the Committee of Management. This Committee of Management was constituted by the court itself. And my lord, their the special officer is in possession, and my lord, the assistant manager of Ashutosh Datta is representing the Committee of Management. So, my lord, I am submitting to your lordship that on this application, do not pass the orders which have been prayed for. Because
So
you
which page is the order passed last occasion?
108.
108.
108.
Yes.
The last page. Kindly direct the special officer to hold a meeting of the parties, put an end to the lease, and then, my lord,
Liberty granted.
yes, take necessary steps for the purpose of taking steps against the lessee. That should be the proper order. There is no other order can be passed on this application.
Mr. Withdrawal,
Special officer minutes.
for the appearing for the beneficiaries of the estate of Maharaja Kameshwar Singh, since deceased. Moves the application GS 17 of 2025. Although the applicants have prayed for the termination of contractual lease dated between Wajaford property described in Schedule 3
21st today.
being part of the estate of
1936.
Maharaja Dhiraja Sri Kameshwar Singh Bahadur.
83.
In terms of the liberty granted by order dated 15th May 2025. But Mr. Mitro submits that he is not pressing the said prayer, and necessary orders may be passed upon the special officers to hold a meeting with the beneficiaries of the estate and the members of the committee. Upon perusing the order dated 15th May 2025, and upon hearing the learned counsel with regard to the application, this court is of the view that necessary purpose will be served if the special officer appointed with regard to the estate of Maharaja Kameshwar Singh, since deceased, to hold a meeting of the beneficiaries and other members of the committee and take a decision with regard to the eviction of the lessee with regard to the Schedule A property being part of the estate of Maharaja Dhiraja Sri Kameshwar Singh Bahal.
After terminating the lease dated.
I'm directed to take a decision, not straight away I'm directing to.
Very well, very well.
Upon holding meeting with the members of the committee and with the present beneficiaries, Srimati Kamsundari Devi, Sri Rajeshwar Singh, and Sri Kapileshwar Singh, and other members whom the learned special officer thinks fit, necessary decision with regard to termination of the lease shall be taken by the
Lease dated 21st January.
mentioned in this thing.
Yeah, page 83. 83. The lease has been annexed.
Determination of contractual
Yes, well,
for the master summons.
yes, I have seen that. That is not the proper. Kindly let's come to page 83. Yes. 83A, because 83 can't be, it is such an old document, it can't be read. Kindly turn over the page. 83A,
21st January
1936.
dated 21st day of January 1936. Top. Necessary decision.
Report করতে বলবো জজকে।
1936 marked annexure D to this application.
And make a report to your lordship. I want my lord him to come back before lord.
And submit a report to this court
Within 3 weeks. In সপ্তাহে হবে।
the report before this court on or before 30th July 2025.
Lordship.
Is hereby made clear that this court has not gone into the merits of the lease and rights of the parties,
Very grateful.
and these opportunities are left to the parties to discuss with the special officer and thereafter arrive at a decision.
Very grateful.
So shall I keep it on 2nd August?
2nd August. Yeah.
Saturday?
Yes.
It's a working Saturday.
Yes, I think my lord, your lordship will do that. Then that will force my learned juniors to come. I shall come, but yes,
Some of the matters I have kept on 2nd
yeah,
August.
you kindly keep it on 2nd August. I think it's a good idea.
Okay, let this matter appear on 1st August 2025 within first 5 matters.
Keep it on the 2nd of August.
No, no,
At least your lordship will have some work to do. I am sure, my lord.
2nd of August
Yes,
2026. Anyway, if you are unable to come, I shall definitely accommodate.
But I don't see any reason why I should be unable to come. Well, very grateful to your lordship.
No, no, ওটা দরকার নেই, just 2nd August 2025.
Item number 12,
That kindly leave be granted minor to file this Gokalatma in the department.
Leave, lastly লিখে দিন, leave is granted to the learned advocate for the applicants to file the Gokalatnama in the department.
তো execution তো
Just easy.
Yes.
But may I, Milord?
Yes, call. Item 12.
Item 12.
Yes.
Milord, I appear on behalf of the petitioner in an execution
GA2.
application. GA2 is my
I am the
application.
decree holder. I
And
am led
nature
by
of the
Mr.
application.
Gupta on the virtual mode.
Two affidavits are complete.
Complete. May I, Milord, file the reply with regard to my application, which is in the nature of section 47 application. Now, before I place the facts, Milord, mentioned in the application, I must tell your lordship about one incident that in suit was decreed ex parte. I appear on behalf of the joint administrators. A building commonly known as Chatterjee International Center. Joint administrators were appointed by this honorable court in order to ensure that the state property is properly administered and proper maintenance is being done. Now, at ex parte decree, obviously I was not a party, not served. Then in the execution application, we were served, the joint administrators. After service, Milord, we appeared and we took out this application, which is in the nature of section 47, basically on the ground of fraud, that certain questions are to be determined before proceeding further in the execution application. Now, my lord, kindly takes up my application once.
Only one humble prayer, my lord. I appear for the decree holder. Before my learned senior friend places the application, but may I make one humble submission? I have an objection with regard to the maintainability of the application.
You have taken it.
But so is it your lordship's pleasure that I?
No.
Yes, I have taken it in the opposition, but is it your lordship's pleasure that I argue first, or my lord, my learned senior friend would have, because I object to the maintainability of the application. Whatever your lordship deems fit.
But you have taken in your affidavits.
Yes, I have taken in my affidavit.
Now, my lord, before that, my lord, one document is very important to be produced before the court, which the decree holder has avoided for some time, and that has been recorded in the orders passed in this application for proper adjudication of the issues raised in this application. Kindly comes to, my lord, page 68 once. Then the court will understand, my lord, why this application has been filed and why there is an allegation of fraud. Several orders have been passed directing them. But page 68 is the last annexure of my application. In spite of several directions, they have not produced a copy of the plaint. Kindly comes to the order dated 25th September 2023 once.
24th July.
Well, at page 68 of my application, GA2. Yes.
That is a different application.
Huh?
For this supplementary.
Yes, lordship is probably looking at the supplementary. Well, lordship then takes my copy because this document needs to be brought on record. And
Anyway, let me put it up on some other.
yes, but kindly sees this, Lord, why I am making this submission.
GA2 is not with.
Okay.
GA2 has to appear because before proceeding execution, section 47 has to be heard. Otherwise, the application will become redundant. অন্য একদিন থাকবে, বাট এই অর্ডারটা আমি দেখাতে চাইছি তার কারণ অনেক ডিরেকশন থাকা সত্ত্বেও প্লেনটা আজ অবধি
In terms of that order, this
yes
should be in the
kindly fix a date, direct them to produce the plaint in terms of this order as well as the other orders passed prior to this.
Only could I make one humble submission, Mulad? The plaint is not traceable. We have tried to find that. It's old record. It's not found. But in the execution, your lordship knows better than anybody else. Executing court can't go behind the decree. The decree is there. The decree has been partly executed as well, in the sense that the property which was directed to be conveyed has already been conveyed. Well, now this is only the execution for the balance part of the decree, which is the damages portion. There were two portions. One is a specific performance, the other is damages. Specific performance decree passed, already executed, deed executed. Second portion, damages, decree passed. We have the the joint administrators have the money in their bank accounts. There are several orders passed in the execution directing them to restrain banking account operations without keeping about that money. In fact, there's also an undertaking by the joint receivers, the joint administrators, that this money is there. All I seek today is, my lord, that money to be given to me. My money, which is part of the decree. Good, bad, indifferent, the decree has never been challenged by anybody. The joint administrators who are there, admittedly, in respect of the, not admittedly, who claim to be there in respect of the entire properties, could have, my lord, challenged the decree when at least this knowledge had come to them. If they are so aggrieved by this order, nothing has been done. Never has this order been assailed. Never has this decree been assailed.
Regarding handing over that money, did you file any separate application?
No.
This is my execution application. In this execution application, I have asked for it.
Without hearing 47, he is asking for decree to be executed.
There is a previous 47 which has been dismissed.
Advocate.
Plaint and my application.
But the plaint is not there in the records. Even if your lordship directs me to produce, I'll not be able to produce.
In terms of the direction dated 25th September 2023, the plaint was required to be produced, but the same is not produced. Let the plaint be produced on or before.
But your lordship will kindly direct the department to produce, because we have searched, it's not there with our records. Your lordship would ask the department to produce, but good, bad, indifferent, even if the plaint is not there. Today, my lord,
is in the order.
On or before 15/7/2025, the application GA 2 of 2024 be also put up on or before 15/7/2025. Let this matter appear on 17/7/2025.
My lord,
Lordship with
only
Mr.
thing, my lord, that week I will not be in town. After 19th, any day.
Lordship, with Mr. Gupta's leave.
I can do it virtually, but this is a
Let
big
this
matter. my lord.
appear on 22nd July.
Absolutely, my lord. Because I will cite few judgments on this.
With Mr. Gupta's leave, may I make one submission?
Lord, the reply file be
My lord,
taken on record because I have filed it.
That, my lord. Second, my lord, in my lord's order has directed that the plane be produced. If my lord could kindly, subject to what falls from my lord, clarify that the department be directed.
Why? It's your suit.
My lord,
I don't have the plan. I'm making submissions. I have made submissions. I don't have the copy of the plan.
Then my lord, kindly,
So
my lord,
let the department produce.
submission because this will have a serious impact that the plaintiff submits.
Yes, I shall argue it. Yes.
Your complaint. Kindly
It
record
was
this.
a very old one, 82 suit, but I don't have the plane.
Extremely obliged.
My lord,
Yes,
reply be taken on record because I have filed my reply to my GA2. Kindly pass.
Affidavit in reply filed with GA2 of 2024 be kept with the record.
Grateful, my lord. Grateful.
Yes, 22nd.
22nd, my lord. I'm grateful.
Grateful.
I was keeping it on the 22nd.
Second, but this.
May I just say this? Possibly Mr. Gupta has not been intimated yet. There is a chance that Mr. Gupta and I will not be in town on the 22nd.
23rd, I have no.
23rd, 21st.
Not a chamber day. Anyway.
24th, in next day possible day.
IC থেকে 24 করে দিই।
Lordship, my lord, I have no objection. না না আমার কোনো অসুবিধা নেই 24th, my lord.
Yes.
Obliged me.
Lordship,
Yes, call the next.
I'm for the award
But
data.
Your Lordship, it's
It
my
has been
application.
dated, my
I
lord.
surprise Your Lordship of certain facts, Your Lordship. They had preferred an appeal from GA4, which was decided by the previous determination that was taking up this matter. Your Lordship,
GA1. GA1 is whose application?
Your Lordship, GA1 is their application. Your Lordship, Sorry, I apologize, Your Lordship. GA1 was their application for dismissal of my execution case.
Which was rejected.
Your Lordship, that was rejected. They assailed that order before an appellate, before a division bench of this honorable court. Lordship, that appeal was dismissed for default. Subsequently, it was restored and very surreptitiously, and I say this with a sense of temerity over here. Last Friday, ex parte, they had obtained an order of stay.
No, my
Yesterday,
lord.
the matter had come up for hearing.
It was taken
Their
up
lordships-
during the course
Lordship,
of.
this was my application, I think, so I am supposed to.
Hmm.
Their lordships had taken up the application based on the merits. Their lordships had indicated their minds to Mr. Banerjee, my learned senior, who was appearing in the said matter on behalf of the award debt of the judgment debtors, and their lordships were minded to dismiss such application with cost, the appeal with costs. They were instructed to take instructions from the client. The client was not available. It was kept today before the appellate side list was to be taken up. Unfortunately, their lordships are not sitting today. So, this order of
Direction
stay.
12 June was appeal is pending against the order dismissing the application of maintainability. Okay.
Yes, Your Lordship.
So maintainability has already been decided against them, to which they have preferred an appeal.
Lordship.
But there was no stay of the.
Yes, Lordship.
No explicit stay.
Lordship will kindly peruse the order dated.
But on 26th June,
Kindly.
last Friday,
Kindly, may I just place the order, my lord? This matter was mentioned this morning on behalf of the appellant, citing urgency and praying for early hearing. The business of the court did not permit us to accede to such request. However, this matter has been called on in the usual course. Nobody appears for the respondent. The list was called on as it's usually called on, my lord. The respondents did not appear. It appears that the respondent has put in execution a compromise decree passed in partition suit. The appellant filed an application before the executing court challenging the maintainability of the execution application contending inter alia that the decree has not become executable as yet. Such application was dismissed, hence this appeal. Mr. Oyan Banerjee, learned advocate representing the appellant, says that the urgency is that the execution application is scheduled to be listed before the executing court on July 1st, 2025. Since the respondent is not represented today, we do not wish to proceed ex parte with this appeal. However, we request the learned executing court to defer the hearing of the execution application for a fortnight for the time being.
This order is not considered.
Lordship, this was supposed to be vacated today. Unfortunately, the bench.
After this order.
No, I will not. I cannot come in the way, Your Lordship. But Your Lordship will kindly just consider adjourning this matter for a week instead of 2 weeks, because this was supposed to be dismissed today.
Let us learn it. Advocate for the degree holder petitioner and learned advocate for the judgment debtor are present. Learned advocate for the judgment debtor submits order dated 26/2025 passed by the Honorable Appeal Court, wherein the executing court was requested to defer the hearing of the execution application for a fortnight for the time being. This court is of the view that in the interest of justice and in terms of the order dated 26 June 2025, the matter should be deferred and opportunity should be granted to parties to obtain necessary orders from the Honorable Appeal Court. That this matter stands adjourned till 22/7/2025.
That your lordship will just kindly consider. Lordship will kindly just consider giving me the leave to mention the matter. Should the appeal court decide otherwise?
It is next week. There is some uncertainty because this
Your
bench may
lordship,
not.
no. That I, your lordship, I bow down.
That is why I am just
I bow
abundant precaution. 22/7/2025 for further orders.
Deeply obliged.
Grateful to you.
In the meantime, if they can serve, give us the copies.
J2, J2.
Item number 14.
My lord, in this matter, Mr. Suman Kumar Dattu was to distinguish the judgment cited by decree holder of Honorable Justice Vibhas Patnaik. He is held up by praying for it may be taken.
Okay, not today. Okay, not this week. Let it be not this week. Item 14, not this week.
Item 15.
Will appear for the petition.
I have done the judgment letter.
Execution application. But I'm seeking execution of a money decree. Now the decree is at page 37. It starts at 13. It was a decree of the year 2014. Appeal was preferred. I will just take your lordship. Page 13. Though the suit was an eviction suit, along with the decree for claim of money of mean profit, which the defendants were enjoying my property, page 13. And the
30 of the judgment.
1-3 starts. Now, page 37 is the portion which I am seeking execution. I drawn up also, yes.
Running page.
Running
Oh,
page.
this is a certified copy.
This certified copy. No, the lordship will get it there. Below my affidavit in support of the tabular statement. Convenient. There is not paginated. Yes. Yes. Page 13 is the starts. The decree starts as page 37. 1-3. The operative portion is at page 37.
Yes.
But the plaintiff will therefore be entitled to occupation charges from the defendant at the rate of 51,200 per month on and from the dates are given, and then at the rate of 66,000 per month the date another rate. So these are the entire breakup given in the order, and this continues from the year 1981 till, my lord, it is in 2007. At the rates have increased in the last 3 lines. The rates have increased up to September 2007. The special referee appointed herein will quantify the occupation charges received by the plaintiff for the period till the vacant possession. Plaintiff is entitled to the aforesaid occupation charges together with interest calculated at the rate of 12% per annum on and from the respective due dates of such occupation charges until receipt thereof. For the purpose of calculation of occupation charges for the period from 2007 until receipt of vacant possession from the defendant, Mr. Ghosh is appointed as special referee. He is entitled to a consolidated remuneration, and the special referee was appointed thereafter. Now, next is that an appeal was preferred. Page 56 by the better copy. Page 56. Well, the page 56, we have a, I'll just, yes, Manar Vashi will kindly see this, Manar. খুব খারাপ অবস্থা, হ্যাঁ না? There's a better copy. Yes, yes, that's the only thing. Legible. এটা আমাকে দে, না, আমি করতে পারবো না। This appeal, ওকে একটা কপি দিয়ে না, সুবিধা হবে। Sorry, man. This appeal is preferred with the prayer for condonation of delay of almost 670 days. The explanation offered for delay in carrying out the misconceived application for review of the decree and for the period is consumed in disposal to application. Mr. Sharkar, learned advocate, senior advocate appearing for the appellant, has questioned the finding of the learned trial judge and has argued that it is not clear from the judgment as to whether the learned judge has proceeded on the basis of the West Bengal Premises Tenancy Act or the Transfer of Property Act. No matter, after all recording, Now the first paragraph, we accordingly direct the appellant to deposit a sum of rupees 3.5 crores. Yes, the first paragraph. Yes. Now after this record, with the register original site within 3 weeks from the date and pay occupation charges at the rate of 3.5 lakhs to the decree holder on and from September 2019 till disposal of the appeal. It was a condition for admitting the appeal. The depositor said sum of rupees 3 for monthly occupation charges shall be without prejudice to the rights and contention of the parties in the appeal. The occupation charges shall be paid by 7th of each succeeding month in, will kindly mark here, in default of compliance of either of the above terms, the decree holder shall be entitled to put the decree into execution. The operation of the decree shall, however, remain stayed until 10th of September 2019, and in the event the occupation charges from the month of September is paid by 7th September, the stay would continue for a further period of 3 weeks from the date, and on compliance of this order, the operation of the decree shall remain stayed till disposal of the appeal. The register original site shall put this money in a nationalized bank yielding the highest return. Now this money, this was directed to be deposited as a condition of stay, was not fulfilled. Nothing was paid. So as nothing was paid, the default clause has come into operation. So there was obviously no stay in the. Now the last para says, the deficit court fees be put within 1 week. In default, the appeal stands dismissed. Thereafter, no steps have been taken. Appeal dismissed. Thereafter, no steps has been taken, and the appeal stood dismissed. Now today, in event there is no stay, the appeal, this order recorded that they were given liberty to put in the money. They have not put in the money. I have now put the decree into execution, and with the interest component, the decree, this order is of 2019, the appeal court's order, and thereafter we have put the decree in execution in 2024. I have done a computation of the money which is due and payable. This is at page 53. Page 53 is a calculation. Okay. Yes, Malad, this is the page 53. If Malad's pleasure to turn to 54 because it's a continuation. The principal 530. So the Malad, you will see the occupation charges, the first, second, third, fourth column. Occupation charges as D. No. But one, A, B, C, D. D is D. F balance. Whatever. Oh, okay. There is a D. Okay. I'm sorry, Malad. It's for me. The print has become very blurred. Now, yes, D. Yes. Malad, the occupation charges as per the court's decree yearly.
What is paid?
Yes. Now this is D. This is D, and now E is what is paid by them, and this is the what is the balance? Balance occupation charges, principal, receivable. It's E and F. F becomes the principal which is receivable.
Yes.
It is 5.18 crores, which is the principal figure. And we add the interest. What the interest which is given in the decree, 12% interest, we have added. So it comes to 518, because after what we have received.
That is
So-
balance occupation.
Yes. So 518 is the figure plus the interest component. No. Yes, the calculation below will kind of look into, because we have added the GST. That may not be the correct calculation which I found, but the principal figure is 518 plus interest is
Which paragraph you are going? That is so far this
the
column
balance
B,
occupation.
balance
F.
occupation.
F, yes.
With up to which year?
No, this is September. September 2007.
Oh, September. That means which page? Annexation?
Oh, sorry, Mal. This is next page. Sorry. I'm very sorry, Mal. This is the next
It's page 54.
Yes. Sorry, Mal.
Now you are confining yourself to
518, that the F, the column F.
column F. Yes, column F.
Column F, balance occupation, principal receivable.
That is from 2007
Up to 2007.
up to 2007. That is 5 crore 18 lakh 44,000.
My lord.
Principal amount.
Principal. Interest is in terms of the decree 12%. The interest takes us to 21 point up to November 2024, which is mentioned in the decree, the interest component.
That is 21 crore 70 lakh.
Yes. এখন তো 21 না 21 কোটি। হ্যাঁ, this is as on 24th of November 2024.
Yes.
Yes.
This includes, that is the total amount, principal plus interest.
Yes, principal plus interest. That includes the principal plus interest. This is 21.70 crores, my lord. That includes the principal come interest, because I have added up the figure is up to September 2007, because the decree provided me of up to September 2007, the decree. Because thereafter, my lord, lordship, I have taken the lordship to the special referee.
7 means that is decree, that is interest, that is up to the date of the decree.
Up to the date of the decree. And thereafter, it was occupation charges, which the special referee was supposed to be. The special referee was supposed to calculate, but that was not done. We did not proceed in that line. So our entitlement remains with regard to this occupation charge up to the decree 30th September, plus the interest. Because the interest stays 12%.
This is up to November 2024.
Because when we filed it.
That is from 24, that is 21 crore 70 lakhs.
Yes, because we filed the application sometimes in December, so the calculation was done till November. So here the figure, yes, but then and it continues because it's till the final. So it's 21.70. Now here, my lord, the decree passed by this honorable court. This is the decree which I showed to your lordship. Now the defendants have their registered office at Rafi Ahmed Kidwai Street, which is within the jurisdiction, and they have a factory also, my lord, I believe in Mohestola, Santoshpur. And in my affidavit in support of the tabular statement, my lord, I have stated in paragraph 13 that they have a factory at Mohestola and a bank at the Bank of Baroda, paste paragraph 13, my lord. But in the affidavit only. Yes. Yeah. The factory which they run and the Bank of Baroda in Kamak Street branch, they have a bank account.
They have a bank account.
Bank account. This is the bank account. Yes, that I don't have a detail of the bank account. So today,
the things you see, so far B is concerned, it is well and good. But if you only seek to execution of any attachment of any property situated outside the jurisdiction of the court, then this court has to.
No,
that is one question.
No, this comes in.
Yes.
If there are multiple properties,
yes,
one within and outside, so the principles of Order 21 Rule 3 will come in. That is a one estate. It becomes a one estate like a partition suit. The concept will come in. I will come to that later. Now, today, my lord, in the tabular statement, in the column 10 of tabular statement, I will be beseeching your lordship, prayer A. Affidavit of asset. Prayer A and B. Yes. Yes, is true. And the bank account, I'm in prayer G, my lord. G,
you are paying.
A and G. G is in the reverse, my lord. Yes, because this is because today, my lord, all bank accounts are linked with the PAN. So I have the PAN number of the judgment data from operating in his bank account linked with the, because we have served them because it's beyond 2 years. The judgment data is appearing, and my pleading in paragraph 18 is that I've said the PAN number. This is the PAN number of the judgment data. नहीं
उधर तो
है ये बाबा no I'm sorry my lord for him देखिए
Page 18.
লিটা আসেনি
ওহো না इसको আমার তো আছে sorry the Xerox says only A for the timing A and G G is तो আছে G টা I'm not asking for D G yes G
He is there.
G is there G for Mr. Chakraborty is also there I think G
Yes, what do you say?
Lordship,
What you can do at this stage?
At this stage, Your Lordship, I'll just point out one incongruity. I'll seek my learned senior's guidance in such regard. Lordship, my learned senior has placed the computation with respect to the occupational charges and the interest component thereto. Lordship has seen that the amount that has been arrived at, that amounts to a total of rupees. Lordship, with the interest component, it should be November 2024 at the rate 12%, 16 crores 52 lakhs 16,105. Corresponding to that, 21 lakhs 70,000 61. I beg your pardon. 21 crores 70 lakhs 61,000 54.
Yes.
So that is 21 crores 20 lakhs 61,095 rupees 22 paisa. Your Lordship will kindly now take up the tabular statement. The amount arrived at has bumped up somehow by 4 crores. Your Lordship, this calculation I will need to peruse and come back with adequate instructions. Your
Yes,
Lordship,
you come with your instructions, file your affidavits in the
Lordship, the
meantime, don't
affidavit-
operate the bank account.
Your Lordship, that Your Lordship would be a little harsh on me, because Your Lordship, the bank account that my learned senior has slated to be, that in effect is linked to he slated out my PAN card number. Now, the moment Your Lordship issues an injunction on my PAN card, it is not peculiar to the one bank account that I may have. It's a running company. Your Lordship will just kindly
Okay,
consider this.
Anyway, for a short period, you please don't operate, okay, without leaving aside. On the next day, you come with relevant particulars.
Your Lordship, in
affidavit
fact,
assets can give some other assets
May not be
No.
with- Come,
In
let
fact-
him file an affidavits, clarifying his position with regard to the quantum, okay?
no you need to file a prayer A the affidavit asset that must come my lord.
Just wait for
that
some
Your
time.
Lordship-
Let him not operate the bank accounts, let him file affidavits with regard to that quantum. And definitely that affidavit.
Restricted to the quantum.
Your Lordship, then
The affidavit restricted to the quantum.
if Your Lordship is inhibiting my use of bank account, let it be to
that
the.
you cannot.
Yes,
No, I
you have to
am
get-
not coming in the way, Your Lordship. Let it be to the principal one, because the interest component I am disputing, Your Lordship.
Yeah, for the time being, my lord,
Let
it's
it
not
be for
that
the
I'm giving yes for the yes.
Your Lordship, just one
Yes,
more
I
aspect.
admit.
Your Lordship,
Through learned counsel for the degree holder. And
Without giving up the other praise, for the timing is 5. Let me 6 crores as a
5
roundabout.
crore.
Whatever. They cannot
Five,
dispute
but-
the entire figure, my lord.
advocate for the judgment data at present, her learned
5 crore
advocates.
18.
Mr. Mitro draws attention to the tabular statement and the order passed by the Honorable Appeal Court, wherein the judgment data was was directed to pay occupational charges. Default. The executing court will proceed with this matter. Stop. It is submitted by the learned counsel for the degree holder that as no occupation charges are paid till today, the executing court should proceed with the execution case. As the learned advocate for the judgment data disputes the quantum of due as reflected in the tabular statement, the judgment debtor is granted opportunity to file an affidavit to this petition on or before 11/7/2025. Reply, if any, by 17/7/2025. Let this matter appear on 22/7/2025. Stop. Pending hearing of this case, the judgment debtors is restrained by an order of injunction from operating its bank accounts linked with its PAN AA capital A 212 IP without keeping apart the sum of, what is the principal sum?
Well, it's
5 crore.
Can you make it
18,000?
6 crores? 6 crores, because that interest will always be there. There may be some
How much?
dividends.
Yes,
5
it's
crore,
518.
Let it be
44,900.
5 crore 518 44990.00, which is the principal sum as submitted by the degree holder. Stop. However, this is without prejudice to the rights of the parties.
Lordship, may I just irk your Lordship and I reprimand myself for this? Your Lordship has given 11 July as the returnable date.
11 July for
filing the
affidavit.
opposition, Your Lordship. I apologize. Your Lordship, my limited instructions are the client, the managing director of the company is based in Rishikesh. He's hit a health embargo. He'll come down to Calcutta on the 9th. It'll take us a week to...
Let it be 18. Reply, if any, by 24. Let this matter appear on 29/7/2025.
Well, the opposition should be restricted to the calculation, because he cannot come up with the opposition of the execution application. It is not an injunction or some other application.
Let him clarify the stand, because you see, executing court's power is limited.
Yes.
Executing court cannot go beyond the
Beyond the degree. So the opposition which we will be filing, that will.
But I have clarified that he submits an.
So restricted to the quantum. That restriction to the quantum only.
No, there is no scope. Even if you file,
Yes, there is no scope.
Section
Yes.
47 is limited in
Yes,
its
yes.
ambit. So, I'm grateful to my learned senior.
Obliged.
Grateful to your Lordship.
14. নোটিশ মানে ওই জাস্ট নেট পেজে থাকবে আর কি, এই সপ্তাহে তা থাকবে না লিস্টে, সোমবারে থাকবে আবার, সোমবার আমি মঙ্গলবারে আর কি।
Item number 16.
Lord, in 16,
Lordship, I appear for the degree holder in this matter, Your Lordship.
Yes, what is the
Your Lordship? Your Lordship, I appear for the decree holder in this matter, Your Lordship. I have instructions to withdraw the execution petition. If Your Lordship recalls, a sum of rupees 33,59,000 was given to us. And in the tabular statement, we had, our prayer was for rupees 37 lakhs. But be that as it may, Your Lordship, I have instructions to withdraw the execution petition.
This is item 16.
16, my Lord.
Yes, Your Lordship.
Learned advocate for the decree holder and learned advocate for the judgment debtor are present. It is submitted by the learned advocate for the decree holder that she has instruction not to proceed with this execution case. Stop. In view of the submission made by learned advocate for the decree holder, EC 71 of 2024 stands disposed as not pressed.
Much.
Interim orders, if any, stand vacated.
Obliged.
Item number 17.
My lord, I appear for the judgment debtor.
I'm appearing for the decree holder, my lord. My lord, I am humbly seeking for 2 weeks adjournment, my lord, in this matter. This matter is pending before the appellate
Learned
bench.
advocates for the parties are present. On the prayer of learned advocate for the decree holder, the matter stands adjourned to 15/7. Okay, so, or 17.
17/7/2025. Grateful one. Thank you.
May it please, Your Lordship, Milord. I am appearing, Milord, in the matter. I was added as a party, Milord, by an order of 10th June 2025 by Your Lordship. Milord, there's a direction there that, Milord, will be filing a supplementary affidavit. I'm only praying, Milord, kindly grant me some more time to file the supplementary affidavit.
আমার edit ওকে তো add করা হয়ে গেছে।
My lord, we have already added, my
We have
lord.
been added, Milord. We have been added. Only this direction which was given, Milord, for filing of additional supplementary affidavit. I'm only praying, Milord, for a extension of time to file this affidavit, Milord.
This is 10th June 2025.
10th June 2025, Milord.
Lordship, the amendments by the department have not been carried out now. Lordship, my learned senior is appearing, Mr. Bagh.
Have you carried out the amendments?
My lord, we have, my lord, carried out the amendment. Mr. Bagh's client has been impleaded.
Yes.
Has been impleaded as a, my lord, one of the decree holders in my execution proceeding, because we are, my lord, members of the same family. Two of them had filed the execution, one was left out. So his client has now been added. My lord, there is an order where my lord had injuncted, or my lord directed the RBI to keep apart a sum of the decretal sum in the account that's there. But I am seeking for disbursal of the fund today, my lord. There is no, they had initiated in May 2025, they said that they were going to prefer an appeal. We are in July today. My lord, kindly.
Opportunity was granted.
Milord, that was the order of 15th May. My learned friend is referring to the order of 15th May, Milord.
Did you file any additional supplementary affidavit which you sought to file?
Milord, we have not, Milord. That's the reason, Milord, we need a short, Milord, extension of this direction, Milord.
Yes, record. Learned advocates for the decree holder and learned advocate for the judgment daters and learned advocate for the added parties present, as submitted by Mr. Bagh, that an additional supplementary affidavit is required to be filed and prays for extension of time to file the said supplementary affidavit. The time to file supplementary affidavit is extended till 11/7/2025. Let this matter appear on 15/7/2025.
I'm very deeply obliged, Milord. Very deeply obliged.
I'm taking it on 15.
My lord, kindly makes it clear that in the event they don't, my lord, get it. No, from April, my lord, we are waiting, my lord. 3 months.
The amount is secured.
Amount is secured, but it's execution at the end of the day, my lord. I am entitled to the money, and it's a huge
Milord,
money. 20
I'm supporting what my learned friend is submitting, Milord, because we are on the same side.
15 July. 15 July.
I'm deeply obliged, Milord.
Item number 19.
May it please your lordship, my lord, I am seeking to execute a decree, my lord, passed on account of mean profit, dated 9 January 2017. Now your lordship has directed us to serve the copy of the application. My lord, we have served, and my lord, they have received it. Yes, deliver. Both, right? Now, my lord, if your lordship kindly takes, my lord, page 90 for once. Page 90 of the application for the funds.
Service.
Yes.
Page 19.
90. This is what I'm seeking to execute. Your lordship kindly takes, my lord, such and such during his lifetime has suffered a decree for eviction and mean profit. The delivery of possession of the flat in question had taken place during the lifetime. The claim on account of mean profit has remained pending. The commissioner has filed a report in respect of such and such. The report of it is not challenged. Enforceability upon the substituted defendant is, however, under challenge. Such and such appearing on behalf of the substituted defendant submits that at the highest, the substituted defendant may be liable to the extent she has suffered at the estate of the although an attempt was made to pursue this court to accept that the claim on account of main profit is not at all enforceable and the said amount cannot be enforced even on the estate of the deceased, but the same appears to be contrary to law since it is well established that the legal heirs of reason of the definition of legal representative in the Code of Civil Procedure would be liable for the liabilities of the deceased insofar as to the extent they succeed to the estate of the deceased. The substituted defendant has filed an affidavit wherefrom it appears that at the relevant time the original defendant owned a very valuable property as such and such, fully described in the deed of conveyance stated such and such, along with a sum of rupees 14 lakhs. The substituted defendant cannot in law resist execution of the decree in respect of the said two properties, namely such and such. Under such circumstances, there shall be a decree in terms of prayer B of the petition, which is, my lord, the mean profit, which is assessed at in excess of 7 crores odd, my lord. And there was an injunction order passed. My lord, today we are seeking to execute the decree, my lord, by, my lord, seeking your lordship's assistance.
This order was passed when?
My lord, this order was passed in 9th January 2017. Now, my lord, in the meantime, your lordship will find from the order that the name of the substituted defendant was Srimati Shanta Mahanavis, and Colonel Mahanavis was the original defendant. Both of them have expired. They were issueless, my lord, as a result of which.
Yeah, you have made party whom? The judge. Whom have you issued
notice? Yes, they are, my lord, basically the nephew of the original defendant.
No. The present judgment
The
debtors.
present judgment debtors are the nephews of the original defendant. The reason being, my lord, both, my lord, the original defendant as well as his widow, my lord, was issueless. They have expired, my lord. Admitted fact. They have expired. So therefore, my lord, in terms of the Hindu Succession Act and more fully, my lord, Section 8, my lord, the estate devolved upon, my lord, the nephews of the original defendant, since it is in respect of an immovable property. So that is
They are the original defendant's brother's son.
No. Yes, brother's son.
1 and 2.
1 and 2. Brother's son. So Section 8, my lord, comes into existence. It finally takes, my lord, Section 8 for once, my lord, of the Hindu Succession Act at the point of. But Section 8, General Rules of Succession is, I'm sorry. Lord, general rules of succession in case of males. The property of male Hindu dying intestate shall devolve according to the provisions of this chapter. Has my lord got it?
This is the schedule.
Schedule, yes.
Okay, one has to be class 1 of schedule has to be followed.
Right. So if there is, my lord,
Yes.
the lordship will find class 2 because no legal representatives, my lord, as established in class 1. So it is class 2, brother's son. Entry number 4.
Yes. So this Orno Mahalanobis and Shayan Mahalanobis.
Yes.
Are the full brothers. Both are the full brothers.
Brother's son.
Brother's son. Full brother's son.
Full brother's
of the deceased defendant.
Original defendant. And my lord, we have got information that they are also the nominee, my lord, of the immovable property. And my lord, I'm only seeking,
Yes.
my lord, to execute the decree in terms of the property which has devolved upon, my lord, the substituted, my lord, judgment papers from the original. Kindly takes, my lord, also section 50 of the Code of Civil Procedure 99. Legal representatives, section 50. Where a judgment debtor dies before the decree has been fully satisfied, the holder of the decree may apply to the court which passed it to execute the same against the legal representative of the deceased. Where the decree is executed against such legal shall only be liable to the extent of the property of the deceased which has come to his hands and has not been fully disposed. So, my lord, I am seeking to execute, my lord, the decree by, my lord, attachment and sale of the immovable property, which is, my lord, recorded by way of an affidavit by the widow of, my lord, the original defendant. That is, my lord, reflected in the decree itself of 9 January 2017, along with, my lord, 14 lakhs. And, my lord, kindly also takes, my lord, the tabular statement for once, my lord. Your lordship will find there, there G.
Yes.
So, to the extent of what has devolved upon them, the substituted, now these substituted judgment debtors, they should, my lord, file an affidavit of assets stating what has devolved upon them.
Present, what are you seeking?
My lord, at present, my lord, there is already an order of injunction.
Where is that order?
Yes. Your lordship will kindly takes, my lord, page 90. Now, kindly takes, my lord, page 91. The last paragraph, last line. The order of injunction passed on such and such in respect of flat number 1F shall continue till the decree is executed. So this order of injunction is also there, which your lordship has also, my lord, continued by your lordship's order of 22nd May 2025. So at this moment, if since, my lord, the substituted judgment debtors are not being represented, so, my lord, there should be an attachment. A receiver may be appointed, and, my lord, sale be proceeded with, my lord, either by way of public auction or by way of public private treaty.
Yes. Which that is?
Your lordship will find page 91.
Yes.
Flat number 1F on the first floor, situated at the building.
Last place.
And your lordship kindly.
This is the original degree, okay?
This is the original
degree.
Yes.
And you have sought execution under what mode?
Under your lordship will takes, my lord.
That is tabular by 2 of the tabular statement.
Yes. BC.
No, B.
Yes, B is the bank account. 14 lakhs.
14 lakhs is F.
14 lakhs is.
So this page. Yes.
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 15 lakhs is B. A is already there. B, my lord, I am seeking. C, I am seeking. And, my lord, lordship can also pass, my lord, F as well as G. And in fact, my lord, the drawn up decree, it starts from page 129, and at the last page, last page of, my lord, the decree, the lordship will find that there is a mention of that immovable property. Starts from page
129.
Yes, 129.
Yes, record and on. Run its pocket for the petitioner degree holder is present.
None appears for the judgment dated in spite of service of notice. Let the affidavit of service file be kept with the record. Learned advocate for the petitioner degree holder draws attention the order asked by the coordinate bench of this court on 9th January 2017, whereby the learned bench was pleased to pass a decree in terms of prayer B of the petition, and it was also observed that the liability of Mrs. Shanta Mahalanobis is restricted to the flat in question and also a sum of rupees 14 lakhs. Learned advocate draws attention to the order passed on 9 January 2017, wherein it is observed that the original defendant owns a property at Shakespeare. Defendant owned a property at Shakespeare Shoroni, being flat number 1F on the first floor, situated in a building more fully described in the deed of conveyance dated 17th June 2003. Stop. And a sum of rupees 14 lakhs. Stop. Learned advocate submits that in the facts and circumstances, prior A, B, and C of the similar statement passed. Hearing the learned advocates and considering the facts of the case, this court is of the view that at this stage there should be an order restraining the judgment debtor and their main and agents from operating their bank account number 005010132237 of Axis Bank Limited, Kolkata main branch. And also, a receiver should be appointed to inspect flat number 1F, Best Cooperative Housing Society Limited. Calcutta. Yes, which page is the particulars of flat given?
Yes, we have page 134.
134. Yes. Situated at 1F on the first floor in the building of society constructed on the said land, being premises number 4 Shakespeare Shoroni, Kolkata 7,71,000. Yes, yes.
Along yes, Shakespeare Shoroni along with the car parking.
Oh, along with the car parking space. Thus, the judgment debtors are restrained by an order of injunction from operating account number 00501010132237 Axis Bank Limited, Kolkata main branch for a period of 5 weeks. Stop. Dash is appointed as learned receiver. Expect flat number 1F, Embassy Cooperative Housing Society Limited. Page 1?
134.
134. in premises number 4 Shakespeare Shoroni, Kolkata 7,71,000, along with car parking space. Learned receiver shall take a symbolic possession of the said flat and cause necessary inspection of the same upon notice to both the decree holder and the judgment debtor. Upon taking symbolic possession of the said flat and upon causing necessary inspection of the same, the learned receiver shall submit the report on or before 25/7/2025. Let this matter appear on 29/7/2025.
To humble press, may this order be communicated to the bank so that the bank is well aware of this order. Not to
Yes. The remuneration of the learned receiver is fixed at dash. Stop. Both the learned receiver and the special officer, the learned advocates for the petitioner is granted opportunity to communicate the bank authorities about the said order.
And actually, kindly considers create G for once because the fee is in excess of 7 crores odd. So 14 lakhs and the flat might not satisfy the entirety. So if they can file an affidavit of assets, declaring what they have inherited from the
On the next day, okay, let us see. Let us obtain the report.
Written up.
Yes.
Chamber application urgent matter, item number 20.
I appear for the defendant number 1. I have filed an application GS7 for amendment of my fixed. In the last application, I had sought extension of time to file my reply, but I have prepared.
Where is your application GS7?
Only see the scope of the suit. When you come to page 3.
Page
3.
Yes.
Lord, the original plaintiff has sought for these declarations. The declaration that the plaintiff is an heir and legal representative of such Chaudhary is essentially along with defendant numbers 2, 3, and 4. Sorry, 1, 3, and 4. Declaration that the adoption, if any, of the defendant number by the either of such Chaudhary is legal rather than the decree for delivery of and cancellation of the adoption whereunder the defendant number has been adopted by the second. Just going to the background of the matter, Narayan Prasad Chaudhary were three brothers and 2 sisters.
This is the relief sought for.
This is the relief sought for in the plea. Kindly come to the question. Original plaintiff, Narayan Prasad Chaudhary, defendant number 1, Ramchand Chaudhary, 3 and 4, Ishfa Kajaria and Mandi Chajaria, along with one brother, Bhavati Prasad Chaudhary were brothers and sisters. Except for Bhavati Prasad Chaudhary, all were married. Bhavati Prasad Chaudhary remained bachelor throughout his life. During his lifetime, he had adopted defendant number 2.
These are your case in your written statement.
May I just?
Yes. So
regarding your amendment petition, let me call, this is your amendment petition, I believe.
Yes.
Yes. This is the facts.
Now, my lord,
When was the suit filed?
57.
Yes.
Now, my lord, finally comes to page 7. Application.
Yes.
Lord, during the pendency of this suit, the said Narayan Prasad Chaudhary had entered into a memorandum of settlement. Now, kindly comes to my lord, page 11. The first paragraph. Whereas due to certain misgivings and ill feelings and then prevailing with the family, the first party had filed suit number 112/27 in the Honorable High Court at Calcutta, challenging the said deed of adoption of Sarvesh Chaudhary by his younger brother and the said Bhagavati Prasad. Pausing here for a moment. Lord, this suit has been mentioned in this memo. Now, my lord, we kindly comes to page 30. Very first. The first party admits and acknowledges that Sarvesh Chaudhary, the eldest natural born son of the second party and the third party, was legally and validly adopted by the said Bhagavati Prasad Chaudhary since deceased as per the said deed of adoption dated September 2, 1972, and also according to the Hindu rites and customs with regard to adoption as Guru. The first party confirmed that he was present at the time of adoption and was also a witness to the said deed of adoption, and that his brother Bhagavati Prasad was mentally and otherwise competent to adopt us. Similar, here the suit pertains to a declaration that he was lunatic, that he was incompetent to execute any deed. Hence, that deed of adoption is to be declared as null and void, and that upon the death of that brother, my lord, since he did not have a class 1 heir, the class 2 heirs, being the brothers and sisters, becomes his legal heirs and so this suit was filed on that premise. Now, my lord, in this suit, my lord, an application was filed for injunction. That injunction order was never granted to them, my lord. They preferred an appeal. My lord, this appeal court's order, your lordship will find it in my affidavit in this.
Which affidavit in reply?
That's the only annexation for page 7.
Page
7. No, my lord, this is, I'm saying the page 7 of the, that's the only annexure. I think it's not been paginated.
Yes.
This was the appeal court's order. Lord, appeal was preferred because no injunction order was granted. It kindly comes to Lord, the internal page of this order, Lord. Page 13. It's a very categorical observation of the Honorable Division Bench. Lord, somewhere in the middle of this first paragraph, Lord, starts with the word after his own affair. The line starts with after his own affair.
Page 13.
Page 13. In between this page, Lord, the words starting with after his own affairs. Middle of the paragraph. The line starts with after his own affairs. The 11th line from the bottom of the first paragraph.
Yes, in the deed of declaration dated.
In the deed of declaration dated 8 April 1968, whereas partition of the original premises number such and such was effected, Bhagwati Prasad was a signatory. The appellant was also the signatory to the said deed. The appellant accepted the said deed of declaration and obtained advantage of his share in the said premises as declared. Similarly, in the agreement of arbitration dated such and such and the award dated such and such, the said Bhagwati Prasad was a party and had signed both the agreement and the award along with the appellant. The appellant accepted the said award. In view of the aforesaid, the appellant at that stage, the appellant at this stage is prima facie stopped from contending that the said Bhagwati was a lunatic and claiming interlocutory leave on that basis. So, my lord, pausing here for a moment, my lord, this appeal was also dismissed. Thereafter, my lord, they lost interest in the matter. And subsequently, my lord, I have shown your lordship the memorandum of settlement from my application. He, during his last days, my lord, accepted that yes, Bhagwati was not lunatic. Bhagwati Prasad Chaudhary did adopt a son, and I was a witness to the rights of adoption as also the witness to the deed of adoption. But this is the fact, my lord, that I want to bring it on record. Because this deed of memorandum of settlement, lord, was executed in 1990. Now, at one point, my learned friend on the other side has taken that after 27 years of execution of this deed of adoption, this deed of memorandum of settlement, I have come up before this honorable court for amending my written statement. The written statement was filed sometimes in 1988. So, my lord, his other point is, my lord, that after 37 years of my filing of my written statement, I have come up. My answer to that is, my lord, from the initial refusal of injunction, my lord, till today, 37 years have passed. They have, the original plaintiff died in sometimes in 2003 and had no substitution application was taken out till 2005 or 6. So they had actually left it, the suit had been awaited, then they filed an application for amendment, substitution and setting aside of the abatement. That was allowed, my lord. Thereafter also they never took any steps for hearing the suit. Defendant number 5 died, who's the relative of the plaintiffs, my lord. They did not take any steps till last year. They filed an application last year, Lord, GA6. Lord,
how many times this suit appeared for hearing of the interlocutory cases or something?
Interlocutory cases were, the first interlocutory application was dismissed in 87 only. Thereafter, they never took any steps for having the suit heard. Lord, may I just take your lordship through the provisions of the of Order 6, Rule 7.
No, that is there. That is the Order 6, Rule 17.
No, just one for my satisfaction, Lord. May I just place Order 6, Rule 7?
That means where the amendment is formal in nature and does not change the nature of the suit.
No, I am not on that.
That is there.
I'm on,
and the trial has not commenced.
I'm on something else more than that.
Yes.
Order 6, Rule 17 says, the court may, at any stage of the proceedings, I allow either party to alter or amend his pleading in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary. Now, my lord, very important words. For the purpose of determining the real questions and controversy between the parties. Here, my lord, what the suit is that he says Bhagwati Prasad Chaudhary was a lunatic. He could not have executed a deed of adoption, adopting defendant number 2. Whereas subsequent to that, my lord, the same original plaintiff executes a memorandum of settlement. He says, I was present when the adoption rights were being carried out. I am a witness to the deed of adoption, and that is what he is challenging. And that too after the death of Bhagavati Prasad Chaudhary. Now, my lord, Bhagavati Prasad Chaudhary died sometimes in কবে মারা গেছে বলতো?
বলো না স্যার, কেন এত বলছো?
No, was this condition there that the suit will be unconditionally withdrawn in the part of the settlement?
Lord, kindly let us read the
Paragraph 4, paragraph 4.
Lord, may I-
So you said the said Narayan Prasad Chaudhary also agreed to unconditionally
Yes,
withdraw
yes,
the instruction.
yes, yes.
Was that made?
Yes, yes,
Yes.
Lord,
Yes,
kindly comes to
that's there, Manoj, that's there.
kindly comes
Does
to
not wish to
page
proceed with
13.
the suit.
Page 13
Yeah,
of my
page 13.
application. Page 13. That's the part of the memorandum of settlement.
Running page 13.
Running page 13. Lord. Internal page 7.
Yes, last paragraph.
Last paragraph. The first party has agreed to unconditionally withdraw the said suit number such and such and not to proceed until it is withdrawn. Lord, I'll just, I'm so sorry, my lord, kindly comes to the first page of the memorandum of settlement. Page 7. Memorandum settlement made on this blank such and such day of 1998 between Narayan Prasad Chaudhary, son of Lequidation Chaudhary, residing at such and such, hereinafter referred to as the first party, very important, which expression shall, unless excluded or repugnant to the context, be deemed to include his heirs, executors, administrators, representatives, or who are the present plaintiffs? Were the heirs of Narayan Prasad Chaudhary.
That means this is during the pendency of the suit.
This is during the pendency of the suit. And after they had lost their appeal also. He acknowledged that there was some misgivings between the family members and hence he had filed this suit. So, my lord, now, my lord, since they are wanting to proceed or whatever, my lord, I am not really sure. But this amendment is necessary, my lord, so that I can bring on a subsequent event on record. Otherwise, my lord, tomorrow, when the trial starts, my lord, if I have to deduce evidence of this document, my lord, I will be stopped in as much as they will come up and say it is not pleaded, it is not on record.
Let him conclude on the next day.
But I have nothing much to say, Manoj. Only one point, that is, Manoj, this document is of 1998. He had 27 years to bring in this document, and the suit is of 1988. He had filed his written statement in 1988 itself. It's been 37 years. There is a gross delay, and there is no explanation for that. But kindly see paragraph 6 of his affidavit in support of the master summons. The reason that he has given. But
Shall I record your consent or
no,
your
Malad, there is no consent. There is no consent. This is the delay which your lordship needs to Malad, consider. And Malad, in so far as the document is concerned, the admissibility, veracity, whether it is binding or not, Malad, that is subject to trial. Malad, that cannot be decided here.
delay in filing this application for amendment?
Yes, Malad, that is the
for a period of 35 years.
37 years.
37 years. No, 98.
98 is the document. So that is 27 years have gone by.
7 years.
So that is the whole. And Malad, lordship, but one query fell from your lordship is how many times the suit had appeared for hearing. Malad, it's appeared in 2006, 2018, multiple times.
In your opposition, you have taken that?
No, I have not taken. I have not, since it fell from your lordship. I am only indicating that 2006, 2018, multiple times, Malad, they have been appearing. It's not that.
Interrogatory matters.
Yes, interrogatory matters. They have been appearing. It's not that they didn't know that we want.
Issues are not yet framed.
No, not yet framed.
So it's not that he comes under the second clause.
No, not at all. Malad, I'm not taking this.
Okay, I'm concluding the hearing then.
My lord.
Learned advocate for the plaintiffs and learned advocate for the defendants. You are for all the defendants.
No, defendant number
You are for all the plaintiffs.
Yes, Malad.
And learned advocate for the defendant number 1 are present. Heard learned advocates on the amendment petition 7 of 2025. Hearing stands concluded. At this matter, for 18/7/2025.
Very well. But one more thing, my lord, in the suit, my lord, we had issued the defendant number 1 letters for discovery and inspection of the documents that has not been responded to. My lord, if your lordship kindly.
I'm not aware, my lord. I'll take
It's-
it. These are the things to be considered if the suit, if the trial has commenced.
Yes.
Then the powers of the courts are to some extent limited.
No, my lord, I'm not on this application. Yes, I'm not on this application. It's insofar as the suit is concerned, lordship may list the suit, my lord, on any day, the suit itself.
Let the orders be passed, okay? Thereafter.
Very well, we'll come.
Let the orders be passed, and if the amendment is allowed, then it has to be given effect to.
Madam.
Necessary correction has to be made.
One more line, I filed my affidavit.
Okay, let the affidavit in reply file be kept with the record.
Lordship would kindly consider the admissibility, veracity. I'm not going into that is subject to trial. My lord, whatever is better.
You have submitted with regard to delay.
With regard to delay and nothing else. Nothing else should be admitted.
My lord, as regards, my lord, as regards to item number 23, my lord. Oh, yes, my lord, I have some yes.
For the urgency.
No, 23, there is no urgency. My lord, kindly fixes up because as your lordship recollects, that senior would be addressing your lordship from the Delhi Supreme Court. So today I have some predicament, my lord. Fix it up. Any
not taking the matters on the other side of the lunch break. It is not taking
no.
these matters.
So kindly,
Milord, I am appearing. Milord, I have been briefed to appear before your lordship. Milord, I appeared in this matter. I went to Kolkata so many times and I appeared before your lordships, Milord, as and when this matter was heard, taken up and heard, Milord. But Milord, unfortunately, this time also, Milord, I had that I shall have the privilege of addressing your lordship physically, Milord, by going to the Calcutta High Court, Milord, which is my home High Court, Milord. But unfortunately, I have been running very high fever since since yesterday, Milord. I couldn't make it to Kolkata this time. Otherwise, I have seen my lord's order last day's order, my lord. My lord was pleased to decide to say that my lord will be hearing the no further adjournment shall be given. So, my lord, I tried to prepare myself to the best that I could, but unfortunately, this matter has not been called on. So, my lord, kindly, the Supreme Court will be open from 15th of July. If my lord kindly keeps this matter, my lord, on any time convenient to your lordship, my lord, in the month of September or latest, or in the last week of August, my lord.
I have some difficulty, but since September, is quite. We've been waiting for quite some time, and numerous times this matter has been heard. And
the matter has been heard. Matter has been argued also, my lord. What can be done? The matter is quite, my lord. It takes time, my lord. This is a heavy matter, my lord.
Mr. Chakraborty appears as a senior in decree judgment data number 2.
But I'm for the decree holder, my lord.
The decree holder, my lord, has got 2 lakh rupees. My lord, they are in connivance with the pro forma respondent number 1, my lord, who is the other judgment debtor. And my lord, they have misled the court and got a partial execution of the decree, which is unknown to the court of civil procedure. So, my lord, the decree holder is in receipt of 2 lakh rupees, my lord, and they still say that they are in predicament. My lord, we have made an application for recalling of that order. My lord, my suggested Apurva Sinara has heard that matter, and that I am told that the order is we are expecting an order from his lordship.
On 2nd August, that is a Saturday, that is a working date. If you are agreeable, I can keep it on that day.
I'm fine with whenever.
2nd August.
Yes. It's a working date here.
Okay, very well, my lord. Very well, my lord. I bow down.
Yes, learned advocates for the parties are present. On the submissions of the learned advocates, let this matter appear on 2nd August 2025 within first 5 matters.
Deeply obliged.
Very well.
Yes, item 22.
23. Mine was 23.
Okay.
We were addressing Milords on 23.
On 23. Item number 23.
Obligement.
Yes. 22. What is the urgency? Yes.
Item 22, learned advocates for the parties are present. Let affidavit in opposition file to which GA? GA4 of 2025 be kept with the record. The affidavit in reply may be filed by 15/7/2025. Let this matter appear on 17/7/2025. Yes, 21, yes. Yes. Item 21. Just let me see. What was the order passed on the last occasion? No order. The matter was not taken up yesterday. Yes. Yes. Okay, let this matter appear on 23/7/2025. Let the affidavit in opposition filed to GA3 of 2024 be kept with the record. Affidavit in reply may be filed in the meantime. Wakalatnama by for learned advocate for the plaintiff is granted liberty to file Wakalatnama in course of the day. 23rd. Yes.
My lord, I am mentioning upon notice to the other side for urgent listing. In this matter, I am enjoying injunction since 2014.
Yes.
But the main application is pending. So I am praying for urgent listing of this matter. This is a partition suit of 1935. In that partition suit, my property has been wrongfully included. Honorable Justice Arjit Banerjee has granted me injunction already in the 2014 only.
Yes. So
I want urgent listing of the matter for hearing.
listing of what? Which application?
That application, my application for intervention that this property may be excluded from the estate.
So at present there is an interim order.
Interim order is there.
Okay, give the slip.
My lord, I want to bring some document on record. So if the leave is endorsed by the learned court officer, then I can deposit it in the department, Your Honor.
No, documents for what purpose?
For some additional document, Your Honor.
So is there any application for that?
Yeah.
Is there any application filed to?
In that application, only in support of that application, I want to bring some more document on the record. So that my affidavit is ready.
Supplementary affidavit.
Supplementary affidavit.
Yes, yes.
Much obliged, Your Honor.
Order was passed but many expired in 27 June. This is the death certificate. I already and the part of appointed the commission.
Yes.
And I take this because now the orders may be extended because the before that 26 that is hospitalized and 80 years oxygenated and safe. And now I already making this conduct rate everything, but deposition could not able to take up because this is the hospital and that's why my lord.
So deposition could not be taken up.
Deposition is not because there's an paid that's why and 27 June morning 11:30 or whatever is expired.
So anyway, so he's a witness or he's a party?
No, he's a witness.
Okay, okay.
He was because my lord is enough ways to grant because his wife is a power of attorney holder, but your lordship has given. Kindly take the deposition in that residence. Enough, the lordship grateful to lordship because but unfortunately he is expired. He is suffering from the pneumonia and this.
Anyway, so
lordship.
When is the matter due to appear? Today?
To 15 July, because 5th July, I already talked to the Parthasarathi and Mr. Jury's counsel, Dubey and this Birendra Dubey and this one of the, I already talked to him.
The matter is due to appear on 15th July.
Due to appear on 15th July.
So let it appear on that date as to be mentioned.
That is to be in the meantime, lordship is okay. Lordship, this I will bring to note this same things. I will bring to the notice.
Yes, let it appear as to be mentioned on the date fixed.
Lordship.
And on the particular date, let this matter appear on 15th July as to be mentioned. Okay, let it appear as to be mentioned.
To be mentioned, my lord. Yes. Matter has been settled. Like we mentioned tomorrow, my lord.
Tomorrow, this bench may not sit either on Thursday or thereafter.
Your Lordship, under constraining circumstances, Your Lordship. May I
under constraining circumstances, the Lordship was hearing, my lord, the Andrew matter, where Mr. Joydeep Kaur, my lord, learned senior advocate, was addressing your Lordship.
Yes.
I am being led by Mr. Shuman Dutt, learned senior advocate.
Yes, yes.
Lordship was pleased to fix the matter tomorrow, calling upon hearing of GA. This is the matter, my lord, where certain dues are pending from Andrew. Lordship has fixed the matter tomorrow. But my learned advocate on record, my lord, Mr. Agarwal, he came to know that there is some emergency in his family.
Actually, tomorrow the matter was fixed. Tomorrow the bench will not sit. Okay, so it will remain in the list and some other dates will be fixed thereafter.
Would it be a Lordship pleasure, my lord? Because there are two senior advocates appearing. Would it be a Lordship pleasure to keep this matter any day when Lordship resumes this bench, maybe next week? Then an order may be recorded. We will, as it is, we have communicated before mentioning. We'll communicate, my lord, further. This was the last.
Okay, let it appear as to be mentioned on Friday.
Well, then let it not be there in the list tomorrow at 2 o'clock.
No, let it appear to be mentioned at tomorrow on Thursday.
Thursday. My lord, your Lordship would record an order. We'll communicate in writing to our learned adversary. This
No,
is the
no,
last
no,
one.
no, no order, because matter
Very
is not listed. Let it
Very
appear as
good.
to be mentioned
Any
day after tomorrow.
Thursday, to be mentioned. I'm deeply obliged. Well, may it please your lordship, my lord. I am appearing on behalf of the learned receivers, my lord, who has been appointed in this matter. If your lordship is pleased to take up your lordship's last order of 19th June 2025, passed in GA6.
Let me see.
I have recorded to Dinna, please. At GA26. My lord, this is the order by which your lordship was hearing GA26, where, my lord, plaintiffs have sought for sale of certain properties in this suit for partition.
Yes.
Lordship kindly comes to, my lord, page 3.
Yes.
My lord, there are 4 properties which your lordship, my lord, has observed. They are, my lord, the subject matter of the sale to be held through the receivers. Now, my lord, after this order has been communicated to us, my lord, we have some queries on behalf of the receiver.
So after this GA 26,
yes, my lord,
was disposed.
Yes.
29 was fixed for, of this month was fixed for filing the
my lord, for
report.
completing the procedure relating
Yes,
to the
and
sale
to file the report.
and to file the report. Now, my lord, some queries, because my lord, the learned receivers have already proceeded for sale of other properties.
Yes.
We have faced certain difficulties in these places.
Yes.
Now, my lord, your lordship will find that amongst these 4 properties, 2 properties are in Uttar Pradesh and 2 properties
then
are
you
in
come with a application
suggested.
for clarification.
No, application from receiver, my lord, would not be appropriate.
No,
but I can come up with my lord, some suggestion from our side.
Circulate that
I will
suggestion.
circulate that suggestion and I'll come up, my lord. Your lordship may be pleased to keep this next week. We will be, my lord, accommodating your lordship with some suggestion. Because, my lord, there has to be, my lord, publication in specific newspapers. Police help is necessary. Also, reserve price inclusion is necessary. And lastly, my lord, the date of sale must be mentioned. To avoid all.
Oh, Mr. Gupta is not appearing today.
My lord, Mr. Sengupta is there.
But I would, your lordship, suggestions.
Otherwise, you can do one thing. Upon considering the suggestion, you can also apply.
May I just apply to your lordship of prior to your lordship for Justice Patnaik. Justice Patnaik had passed an order detailing all these particulars. The time frame within which the publication had to be made, the respective newspapers, as well as.
So come with these particulars on the next day.
Exactly,
Yes.
that is what I was.
Yes, record an order.
My lord, may I just place the order for my lord, sir?
Anyway, on the next day with the suggestions also. The matter has come up.
6th of January.
The matter has come up at the instant of the joint receivers for necessary clarifications. The matters stands adjourned till 15/7/2025 for giving necessary particulars and necessary suggestions by the parties. Yes, 15th it will appear.
15th. Deeply obliged.
I'm grateful. My lord, may I place this order's copy with your lordship, my lord? This order
You give it on the next day, along with your suggestions.
Deeply obliged.
Item number 25, 42 dash.
What order? Yes.
On my application.
Yes, I have heard this matter. Yes.
It was fixed for 4 orders.
Yes.
It was fixed for 4 orders.
Yes, 4 orders.
The fair games of the matter appeared, whenever it appears. Just to add the spanner in the wheel, my lord, this is. But when my lord is on the
In terms of the earlier order, okay. In terms of the earlier order, that is on in the month in 2023.
Yes.
2024.
Yes, ma'am.
Our direction was given.
Yes, ma'am.
To carry out that. So there is no appeal against that said order. Okay. That order has reached its finality. So
26th November order, my lord, 2024.
Yes.
I want to purchase now because I have not waived the right of purchase. And they have never appeared, my
How
lord.
much? You have 99, about 80% is sold.
Yes, my lord. The other co-sharers have already affected sale.
Anyway, if you want today I'm passing the orders. If you want, you come with necessary suggestion and clarification. Come with necessary application. Yes, record an order. Yes, your presence will be recorded. Let there be in the facts and circumstances the prayer of the.
My lord, no, my lord. My lord, I have serious objections. My lord, this is the first time they are appearing. Lordship has seen their conduct. My lord, their conduct is such, my lord, I am compelled to say that, my lord, they were waiting in the fence, my lord. They only pounced today when my lord is on the verge of passing an order. I have shown, my lord, orders.
Anyway, after the order being passed, they can come with necessary application.
Yes, my lord. That is up to them.
In the facts and circumstances, the prayer of the plaintiff petitioner stands allowed. Let there be an order in terms of prayer B of the notice of motion dated 23rd June 2023. It is hereby clarified that this order of sale is confined to the shares of defendant number 5, 6, and 7. Fixed 2/8/2025 for filing report by registrar, original site. So let a copy of this order be circulated. The learned advocate appearing for defendant number 5, 6, and 7 submits prays for a stay of the order. And this court is of the view that in the absence of necessary application, no such further stay can be granted, and the prayer for stay is refused.
Item number 26. That got you.
Disposed. না এটা রিপোর্টের জন্য ডেট আছে রিপোর্ট ডিসপোজ হয়নি ফিক্স ফর রিপোর্ট না না এইখানে তো একটা ইয়ে করা হচ্ছে জাস্ট
আমরা বলে দিই আমরা টেক নোটস কাল নেই কাল রাতে
হ্যাঁ 2/8 রিপোর্টের জন্য ডেট রাখা হয়েছে Yes, just a minute. Yes, item number
26. My lord will recall, I had mentioned, I had made submissions on the last occasion. My lord will recall, I said that although, my lord, this is.
Yes, submission will be made from both sides regarding the transfer.
Yes, because my lord, I said, kindly looks at the plaint. The plaint clearly is based on an agreement between the plaintiff and the State Bank of India with regard.
Yes, are you ready today to argue the matter?
Left for the court. Very well, but I can make my submissions. Well, I am the plaintiff.
No, let me consider the written notes of argument. You have filed your written notes.
I've got it ready with me. Kindly record that I filed.
Yes. Record an order. Learned advocate for the plaintiff is present. Today is filed for hearing submissions with regard to the transfer of the case to commercial court. Mr. Ghosh, appearing for the plaintiff, files his written notes of arguments. Let it be kept with the record. The defendant is also granted opportunity to come with written notes of arguments on the next date fixed. Let this matter appear on 14/7/2025.
They were supposed to give it today. Your lordship has recalled. They were supposed to bring the notes today.
No.
So I am seeking for a transfer.
And you on the next day I shall hear you along with the written notes.
Can it be a shorter date? They were supposed to bring the notes.
Actually, from 7 to 11, there is an uncertainty for this regarding this bench to sit.
So one day, day after tomorrow, they should be ready. They should be ready with the notes. It's a very short matter, your lordship.
So let them get some time. Okay. This direction is peremptory.
GA 238 note.
GA whose application?
GA 238 note, which is the first application. Lord, I find
the records are not here.
Lord, the papers have to be called from. Lord, this is not a serious matter. Yes, my lord, this is a serious matter in my
The application, your application.
my application by the state, my lord, and in my respect submission, this needs to be, my lord, decided first, not before any other application can be taken up. Not because the state, not the case of the state.
Earlier, there were many other applications.
Not in fact, not this, not is a.
Kindly, these applications, your lordship, kindly direct to file an affidavit. Without affidavit, this cannot be, should not be heard.
Lord, I have no objection to that, but provided this is not heard prior to all other pending applications. My lord, I'll tell you, lordship, why. My lord, the case of the state is not the entire, my lord, the land, my lord, the subject matter of this proceeding, but has vested in the state, and they have no right to deal with it. And my lord, the acts of the receivers, my lord, have also not been, my lord, not mentioned here. You know, there are multiple applications by parties, you know, who are not parties to the suit, whose properties have been not sold by the joint receivers. Application challenging sale of, setting aside of those sales are pending before my lord. Your lordship can call for a report from the department as to how many applications are pending. And my lord,
I think 2 days ago also I passed an order.
My lord, yes, my lord, because my lord, nobody have, my lord, it's, my lord kindly understands. My lord, it's my lord, the suit between, my lord, between the Kundu Chaudharys, my lord, they are themselves the receiver.
Administrators, no, the scheme was framed under which they were granted liberty to administer the estate.
Yes, my lord, because, my lord, suppressing that the land had vested.
My lord, this is my submission, my lord.
Anyway, you have filed the records. Let them file opposition to that.
Yes, my lord, but my lord, kindly, my lord, said this will be heard before other applications. My lord, kindly just.
In spite of the action of this, my lord, division bench, my lord, they failed to, my lord, produce any satisfactory report before.
Anyway, I shall remember if any other applications are filed, I shall direct service of copy upon the state.
Yes, upon service, we are moving, my lord, application, and all the applications moved before the lordship.
My lord, one after the other, my lord, properties are being sold. My lord, every application you will find, my prayers are not for sale of properties. My lord, so my lord, this issue has to be first decided whether, my lord, they have any right on them. And my lord, that has to be decided in this application. My lord,
whether this property has already been vested or not, your lordship kindly decide.
So you file your opposition.
My lord, today the papers are not there. My lord, may I suggest this?
My lord, my submission is this, my lord, state, West Bengal State Execution Act does not apply.
No, you see, you serve him a copy, okay.
Yes.
Let him deal with that, let him file a reply, thereafter I shall see. Yes, record an order.
My lord, the state, my lord, is already added as a party, my lord, as it was an application of the state, my lord, for being added as a party.
Learned.
And my lord, one thing, my lord, I think, my lord, if I'm not learned from lord, can confirm, my lord, that my lord, this by an order, my lord, by an order passed on this application, my lord, the state note was added as a party.
Yes,
My lord, so no, my lord, whether they have carried out the amendment, because my lord, unless that is done, my lord, anyways they can't proceed.
Now, probably you see, I have fixed. Probably I have fixed 2 matters for orders, that is day after tomorrow. Okay, in this similar matters, 2 other matters of these parties I have fixed for orders day after tomorrow.
Yes,
so
in that case, may this also appear not day after tomorrow, but along with those matters.
No, these matter will take time, okay, because they have to file their affidavits. Those are earlier orders which have passed, okay. Similar matters, anyway, similar matters orders may be passed. If you have any grievance, you apply. But because in that those 2 matters hearing is concluded. So
well, those 2 matters I moved upon service. Well, they did not appear on that.
My lord, I will respect some, kindly, my lord, deliver judgment after hearing this application, my lord, because my lord, the issues, my lord, will go to the very root of the matter, whether my lord, any order for sale can be passed in respect of these properties. My lord, probably my lord, the state advocate couldn't appear on the last occasion.
Just a minute. Yes, record an order. Learned advocate for the petitioner, State of West Bengal, moves GA 238.
My lord.
Of 2022. Let affidavit in opposition be filed by July 15, 2025.
Yes.
Reply, if any, by July 22, 2025. Let this matter appear for hearing on 28/7/2025.
Yes. Not kindly not record this order, not that the state, why this order, the state was added as a party, not in terms of player A and B, and not call for a report from the department whether this has been carried out, not.
The department is directed to submit a report as to whether the necessary directions in terms of order dated 24th August 2022 is carried out. No, you see, day after tomorrow, I fixed 2 matters for orders, similar matters. Anyway, orders could not be passed, more or less regarding sale of a particular property.
That's not, that is the modus operandi, my lord. That is the modus operandi, my lord, for selling of properties not belonging to them.
Then you better do one thing, the matter will appear for orders day after tomorrow.
No, we'll be there, not to.
Day after tomorrow, these 2 matters, same matters will appear for orders. If you want some time, I shall grant you time. I shall not pass the orders.
I'm grateful to Lordship. I'm grateful to Lordship.
Or if you want to contest that, you file your opposition in that.
Yes, without
So those 2 matters, my lord, could appear as to be, my lord, in that case, my lord, may those matters, my lord.
lot of land which my lord paid for my lordship leave regarding sale of that property, unless they produce any document that property has been vested in the state, that is a state property, well, they have no right to my lord, stop from selling.
That is why I have granted you opportunity. You deal with his
So, my lord, in those 2 matters also, my lord, Lordship may give me, my lord, time to file affidavit. My lord, same directions can be there.
The vague prayer, my lord, all the property has been vested in the state of West Bengal. Till date, they have failed to produce any documents stating that these particular lands.
My lord, we'll rely on the provisions of law, my lord, everything will be clear. My lord, friend, let him use an affidavit, my lord, we shall satisfy your lordship.
Anyway, day after tomorrow, these 2 matters will appear. Not these 2 matters,
No,
similar matters.
other 2 matters.
Yes.
So, my lord, item 28 also, my lord, may I also use an affidavit?
See my application, my lord, regarding my lord, praying for your lordship leave regarding sale of the property.
So, my lord, may I use an affidavit, my lord, same
Let me
day?
File affidavit.
Okay.
Let them file.
Item 28, record an order.
Stating my lord, giving particulars that particular land.
Learned advocate for the applicant moves J 280 of 2025. Learned advocate appearing for the state of West Bengal is also present. Let affidavit in opposition be filed by 15/7/2025. Reply, if any, by 22/7/2025. Let this matter appear on 28/7/2025.
My lord, preliminary decree was passed in 1937. My lord, 437, my lord, share has been declared. My lord, 1953 Act has no manner of application because the property cannot be vested. Well, they are not intermediary.
No, suppose there is an order of vesting,
yes,
if the court finds,
yes, my lord,
if you have to show that order is set aside, or
your lordship knows, my lord, better than me, my lord, according to the provision section 4 of the Estate Acquisition Act, it is vesting is automatic, and according to the judgment passed.
No, question is, let the state satisfy that there is an order of vesting,
yes,
and you show that there is no vesting.
Yes. Let them come with the order, that order, they are with the order of vesting. My lord, you must kindly record an order, let them produce, my lord.
No, they have, whatever they have stated in the petition.
I've stated in the petition.
Whatever opposition they have to file in their opposition. Yes, next.
My lord, I am appealing for the applicant in this matter, my lord. On last occasion, my lord was pleased to direct the applicant to carry out paper publication on 19th of March 2025, my lord. Accordingly, I have carried out the paper publication. And I am pressing for prayer B and D. A special officer is required to be appointed.
There is just a minute. So paper publication is made in terms of order dated March 19, 2025.
My lord.
Let me see.
My lord, this is my affidavit of compliance.
Yes, have you marked it by ink?
My lord, in page number 10.
Page number?
10.
10.
At Times of India, my lord, internal page number 10.
Internal page number 10. Okay, GA 106.
My lord, IAGA 106 in civil suit number 343 of 1970. And similarly in the Bengali daily, my lord, in the internal page number
And in Bengali, which page?
my lord,
Bengali newspaper.
my lord, a similar kind of paper publication is also there in the Bengali daily. I do not have the page number in my affidavit. My lord, it has been encircled with red ink, my lord.
Getting the match.
My lord, if I may point it out, my lord. In the Bengali daily, my lord,
That is
getting the what? My lord, it has been flagged, my lord. The Bengali daily has been flagged with red, with the red paper, my lord.
Give the Xerox copy.
My lord.
Yes.
My lord, now.
So
My
you
lord,
are you are for the intervening applicant.
my lord. My lord, if my lord takes the page number 24 of my application, pressing for prayer B and D. My lord, a special officer is required to be appointed for carrying out
Page 22.
24. My lord, 24 of my petition.
24. Yes, you are representing whom?
My lords, for the defendant number 10 for the owners association, I have no objection. I have been intimated and served about this.
My lord, a similar kind of order appears in page number 223 of the 223 in the volume 2 of my petition. In a
Page
similar kind of
223.
223, my lord.
Of volume 2.
My lord, of volume 2, my lord. It's in respect of, it's passed in a different application of similar nature.
Yes, record an order. Learned advocate for the intervening applicant and learned advocate for, you're for?
Defendant number 10, my lord.
Defendant number 10 are present. Necessary compliance by making paper publication is made in terms of order passed on March 19, 2025. Let an affidavit of service be filed in this regard. Hearing of GA 106 of 2025 is concluded. Let the matter appear for orders on 3/7/2025.
Well, the affidavit of service has already been filed, my lord.
No, I have recorded affidavit of service file be kept with the record. 3rd of July for passing orders.
Much obliged.
3রা জুলাইতে পাঠিয়ে দেবেন। ওটা দিয়ে দিন, ফেরত দিয়ে দিন। তিনটের সময় দেখছি আর একটা কল করে নিন, এইটা নিউ মোশনসটা।
My lord, I'm appearing for the applicant in this matter. As per your lordship's last direction, we have for the second time served upon the defendant, Union of India.
Only yesterday, my lord, I have received a copy of this.
Which application is to be heard today?
This is GA4, my application. Your lordship remembers I had apprised your lordship what this application is about. There has been a scheme of amalgamation which has been approved by order of the court. So by that order, I have stepped in this. There have been change of advocates, and the erstwhile advocates, I have been told that they have not been taking proper steps. Now the clients wants to move in and we have come into the picture. My lord, this application only is for me stepping into the shoes of the plaintiff.
Party or you are an applicant?
I am the applicant who is now should be stepping into the shoes of the plaintiff, my lord. My lord, may I take your lordship through only two,
So
three
plaintiff is not represented.
My lord, the plaintiff is no more there because there has been scheme of amalgamation. So whatever was there of the plaintiff, I
So for Union of India.
Yes, right. In 2016, my lord, the amalgamation was there. The company went into liquidation.
You want to take instruction?
Well, yesterday only I have been served a copy of this.
My lord, may I just place two,
And
three pages
I
of
have
this
to file
application
opposition
only, my lord, because this is a
I have
third
to file
occasion. They are
opposition to this petition.
obstructing something.
He has just got the copy. Okay, let him take instruction.
My lord, this is only formal in nature. This is
Not
not.
formal, my lord. They are proceeding with the earlier name, which company is not there.
My lord, kindly
It's
see the
16
prayer
to 25,
portion.
my lord. This application was never moved.
My lord,
Filed in
kindly see
17, but not moved.
Anyway, it is pending for 8 years.
kindly
Okay.
see page 9 of this application. Kindly
No, no,
give
for
support.
8 years, my
It
lord.
is pending for a long period. Let him take instruction. I'm just giving a short.
That kindly gives a very short
On
date, my lord.
26, my lord, on 26, your lordship passed an order, giving it 2 weeks' time, and asked them to serve a copy. Yesterday, I got the copy. Only that order is not updated, my lord.
Very well, my lord. It's my application.
That order is not uploaded.
Yes, record an order. Learned advocate for the applicant intervenant is present. Learned advocate for the defendant prays for time to take instructions with regard to GA4 of 2017. Thus, time is granted and affidavits in opposition may be filed to this application on or before 11/7/2025. Reply, if any, by 15/7/2025. Let this matter appear on 17/7/2025.
Will it be the pleasure of my lord to indicate the matter should be kept fairly at the top, my lord? Humble request, my lord.
After 8 years, they are in hurry now.
Okay, let
My lord,
this,
there has been change of several advocates and now
just a minute. 17 তারিখে কি চারটে তিনটে কি চারটের সময় দেখুন তো কোনো ফিক্স ম্যাটার আছে কিনা। আর চারটের সময় নেই, দুটোর সময় আছে।
It may be 18th or 19th, bro.
Huh?
This would be on 18th, 19th, whatever.
I'm keeping it on 17th.
my lord.
17th, some difficulty is there.
Yes.
17th, some difficulty is there. Can't you keep it on 18th, bro?
Let this matter appear on 18/7/2025.
Yes.
Within first 5 matters.
So grateful, my lord.
Right.
Yes.
Your lordship, I am for the defendant.
I am appearing on behalf of the plaintiff, my lord. My witness is here. One small thing, while going through the documents, this is a suit, this is a money suit, claims arising out of reimbursement of KMC dues. Now, the best of my understanding, my lord, in all likelihood, the matter should be posted to the commercial division. If I may just indicate, my lord, what Judge Saib ke din? My lord, 7. Agreements relating to immovable property used exclusively in trade and commerce, because this is the document which I would.
Depositions are over in this case.
So lordship, in this case, I am for the defendant. In lordship inspection, we couldn't carry out the inspection. Your
There
lordship.
has been several instances where they had asked for time, and there was a situation when they had to.
No, if the case is to be transferred, I have to hear both the advocates. Thereafter, I shall transfer the case. If the case is to be transferred,
my lord,
let me hear both sides.
Very well. But as far as what my learned senior friend is submitting, that the discovery and inspection part on their
Yes, your lordship,
side is not done, they had to deposit a cost of 10,000 rupees also. Then, in spite of that, they could not complete the same from their side.
My client informed us late, therefore you couldn't carry out the inspection, your lordship. If your lordship give us a time for inspecting the document,
We have sent them notices inviting them to come and take the necessary inspection. Everything was done at a key. This is the affidavit of service.
but your lordship, the client has informed us late, therefore you couldn't carry out the inspection.
At times,
When was the order passed regarding inspection? Last order by this court?
2024. 2020 last order inspection last order.
23rd.
13th May 2025, lordship.
See, last occasion you did not appear also.
Last occasion also they did not appear.
Oh, your lordship, if lordship
Yes,
grants
record an order.
for inspecting the document, your lordship.
Learned advocates for the parties are present. Till today, the defendants did not take inspection of the documents. Top. However, in the interest of justice, a last opportunity is granted to the defendants to cause inspections of the documents of the plaintiff.
And in fact, we have already filed a judge's brief of document. They never bothered to send us anything from their side.
On or before
The opportunity.
19/7/2025.
Thereafter, my lord shall decide whether to post it to commercial.
19/7/2025. Did they file their documents?
No, nothing. And that part has been closed also.
Document also, your lordship.
Anyway, 19/7/2025. Let this matter appear on 23/7/2025 with regard to the point of transfer
To the commercial division.
to the commercial court.
We have filed a judge's brief of document. If my lord may be pleased to record the same. The plaintiff's judge's brief has already been filed.
Yes, yes.
File করেছি।
Anyway, if it is there, it is there. Okay, no further order is recorded.
আমাদেরটা দেয়া।
Item number 31.
But I appear for the petitioner, but on the last day, the time was extended to the for the receiver to file an opposition to this, but no opposition has been filed.
31.
But
31.
Okay,
Okay, this matter. Yes, let this matter be taken up on the next day.
Very well, Malad. Only difficulty is Malad Lordship had extended the
So
interim
this is
order.
the similar matter.
Yes, yes.
But all are similar.
Challenged by an objector.
Yes.
I was telling you, Lordship, not properties of third parties are being
Okay, 31.
31.
Let this matter appear on 22/7/2025.
Very well. But only one difficulty, Malad. Lordship had extended the interim order for 6 weeks on 6th May. That has already elapsed. If your Lordship could kindly reimpose the order of injunction which was passed earlier.
28 তারিখে করেছি তাহলে 28 তারিখে করে দিন let this matter appear on 28/7/2025 interim order granted earlier stands extended for a period of 6 weeks or till further orders whichever is earlier লিখে নিন এটা item 31 তো learned advocates for the applicant, learned advocate for state of West Bengal and learned advocate for the joint receivers are present. Let this matter appear on 28/7/2025. Stop.
Well, time to file affidavit. Time to file affidavit.
The affidavits may be filed in the meantime. The interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
But would not be extended because it has already expired. If your Lordship could reimpose the order of the
Anyway,
very
no, it expired, but the matter was appearing in the
yes,
list.
yes, matter was appearing.
Suppose it expires, or if an application is pending, or the matter could not be taken up,
My lord.
then the court has power to extend.
My lord, very good. Grateful.
My lord, I appear on behalf of the respondent. Lordship might recall in this matter, there was an order passed by your Lordship that my application taking exception to the report of the commissioner should be heard along with this application, which the plaintiff plaintiff has filed. In this application,
That is, your application is GA7 or GA9.
GA9 is the plaintiff's application.
GA9 is your application.
GA9 is plaintiff's application taking the reports of the commissioner of partition on record and to pass a decree. In that application, I had taken a point that there were 2 reports. So unless both reports are taken on record, decree cannot be passed. And Lordship will not invited the parties to file 1-page note. Well, just see this note, Lordship will understand why I am objecting at
What was the last order passed? This is 17th December.
No, last order
By
Lordship
Justice
had passed
Mukherjee's order
on 10th of June 2025, Lordship's order.
May I submit one thing? In
Yes.
the 10th of June, in the last hearing, I have submitted a affidavit of reply with affidavit of service. After coming out of the order of your lordships, they find that that is not recorded. Kindly take it on.
Let me see the order, last order.
10 তারিখ জুনের 10 তারিখের লাস্ট হ্যাঁ ওই আমাদের অ্যাপ্লিকেশন এক্সেপশনটা হ্যাঁ ওইটাই
রেকর্ড করে দিন আজকে রেকর্ড সেদিন করেননি
হ্যাঁ জজ সাহেবের
Yes, last
Then it
report
got to
was
correct.
directed to be submitted. That is 7th April 2017, along with annexures as well as your written notes of argument.
I have prepared a short notes. Point is very short and limited. Kindly sees 1-page note. Lordship will find why I am objecting at this belated stage.
So this is your ground of objection.
And consider the order which I have annexed, 17 December 2019. Unless that is not rectified, very difficult.
No, these order stands.
Absolutely.
No, the question is
order of 17 December 2019 stands.
Yes,
Kindly
that has to
please
be
that order. I have annexed. Kindly comes to alert the internal page 2 of the order. Internal page 2 of that order.
Page 2, yes.
Second paragraph.
Yes.
Last 4 lines I am reading, Millard. The parties are present in court. Lordship has got that. Last 4 lines.
Page 2.
Page 2. Paragraph starts with the word subsequently. I am reading the last 4 lines of that paragraph.
Yes.
The sentence starts with the words the parties. Lordship,
Yes.
The parties are present in court, namely Malavika Bhattacharya, plaintiff, and the Amitabha Mukherjee, defendant. They agree that 60% of the third floor on the southern side shall be in possession of the defendant as his allotment, and 40% of the third floor on the northern side will be allotted to the plaintiff. Then it's important. The exception taken by the defendant, my client Millard, to the commissioner's report with regard to the third floor therefore fails. So only third floor failed. So remaining other floor still remains. Now what had happened thereafter, Millard? The commissioner of partition went to the suit premises in terms of this order, paid a visit, and allotted some portions. Regarding first and second, there is no problem. He has allotted one particular floor to the plaintiff and the other floor to the defendant. Now, the problem lies, Millard, with regard to the ground floor. First of all, that adjustment has to be made. Secondly, the distribution has to be made. Now, both can't be on the southern side. And that would be evident from the report itself.
You have made your written notes in GA9 of 2024.
GA9, because in my affidavit...
Because GA9 has to be heard and decided.
Heard and decided with my application exception that still remains, Millard. That application, Lordship, on the last day directed to appear, that is also probably appearing in the list. Lordship, ওটা দিন আগের দিনের যে অর্ডারটা ছিল যে আরেকটা অ্যাপ্লিকেশন আনানোর জন্য Lordship has got
that is June 10, 2025. Yes, GA 1933
yes
of 2018 is pending
Yes,
for disposal.
Absolutely.
So that application, in that application also affidavits are exchanged.
And unless that is finally disposed of, no final decree can be passed. That has been contemplated in Order 26, Rule 17.
No, the entire thing is this, that so far the third floor is concerned,
done.
The matter is settled. So far third floor.
Absolutely.
Now parties can
Decree
sell
passed,
also.
Decree passed, distributed.
With regard to third floor.
Absolutely. First and second Millard also.
And ground floor.
No. First ground, nothing had happened. The problem lies in the ground, in fact. Third floor all done, distributed, 60-40. Adjustment of 10% has to be made in respect of the remaining floor. So it has to be either ground, first or second.
Yes.
Now, Millard, first and second allotment has been made. First given to the plaintiff, second given to the defendant. No problem at all. Now, the problem lies with regard to the distribution and ground floor. First of all, adjustment, if at all has to be made, 10% has to be done. Secondly, how the allotment will be done, partition or demarcation will be made when on the face of it, it appears that the commissioner of partition has made an error. Because both he has indicated southern side. Kindly sees the report. It can't be on the southern side, both. Southern, northern, eastern, western. How can it be on the southern side? So unless that is clarified.
Now you see, now the present position is, if the third floor is settled, the matter comes to an end.
Settled, end.
Now with regard to the second floor,
Lordship,
the matter has to be considered.
Not
floor.
only second, ground, first and second in total.
So
kindly sees the prayer, what they have made in the application. No prayer for piecemeal allocation or a decree to be passed in terms thereof. Sees the prayer. That created the difficulty in the application.
So this is GA 1933.
GA9, Lordship would seize, GA9 is the principal application. Kindly see the prayer, Millard, made in
this
the
is a prior application 1933.
And that's my application for exception.
Exception means you want set aside.
Yes.
And the order of Justice Mukherjee was
After that,
in your application.
On their application.
No, 1933.
It is
1933, my application.
So in which order? No. You see, 1933
is my application.
That point of time, that application was not in existence.
Yes.
In 1933,
My lord
Justice
is correct,
Mukherjee was
yes.
pleased to pass 17th
Absolutely,
December.
Absolutely, my lord is absolutely correct.
So is it so that 1933 is disposed?
No, kindly see, my lord, if
let me
It
see
is
what
not
is the order.
in respect of the dwelling house.
Nothing
disposed
record.
of. Third floor
No,
disposed.
whether any scope to pass any further orders?
Possibly, yes.
1933.
Kindly sees the last page, my lord, of the order.
Page 4.
Page 4. It only indicates the distribution to be made in respect of the third floor. And there is no formal recording of the fact that my application has been disposed of. On the contrary, the order says the decree as passed herein shall be drawn up expeditiously, that too with regard to the third floor. Therefore, my objection still stands.
Yes, decree as passed herein be drawn up expeditiously.
In terms of what, my lord? The observation made in the preceding paragraphs?
That decree was
third floor
also.
Third floor. Yes. And the prior observation record.
So thereafter is for consideration of the pending issues.
Yes. So that's the issue they are now raising, decree to be passed. Now, without resolving this, how this can be done, my lord? On the face of it, it's a defective.
So
and consider one provision.
Let me see which paragraph.
My lord, lordship takes up, my lord, then the report itself I have annexed, my lord.
No, which paragraph of your petition?
1933 টা ওই জিএটা কই পুরনো জিএটা 1933 টা কোথায় দেখি just give me a minute's time, my lord. I have categorically indicated, my lord, may I just but that is missing, but the lordship, my lord, kindly takes trouble to see this application. This categorically I have taken this point in one of the paragraphs. Why the report needs to be varied or set aside in my application. Categorical stand that I have taken. And same stand I have taken in my opposition to this instant application. Brief ta koi.
Anyway, so come ready on the next day with your short written notes also.
Only this, my lord. Only this, nothing more. I accept the distribution of first and second. There's no problem. One floor allotted.
You stated that in your written note.
Yes, lordship sees. But unless this is varied, my lord.
Just let me see.
Absolutely. Kindly sees, my lord.
So,
second page.
If first and second is accepted by you, then necessary orders or decrees can be passed with regard to first and second.
But my lord, again, it will create some
first and second, and 50% of the ground floor is accepted.
Ground floor also,
50% is accepted. Only
if you are ready and willing to accept first and second.
First and second, I have no problem. I have indicated in my note.
In your written notes.
But kindly consider the order has to be passed, my lord, in terms of the prayers. In terms of the prayers. There is no prayer for molding of the prayer. Kindly see what they have prayed in this application.
No, I'm considering your exception.
Your exception, yes?
Yes. 1933.
My lord, can my application taking exception be allowed in piecemeal? My objection.
What was the Justice Mukherjee's order?
Only one floor. That
yes,
fits.
one floor.
So rest remains.
Yes. So similarly, thereafter.
I got your point.
Similarly,
I got your point. You were saying that since first and second you are accepting, let that be decided with regard to the objection. That can be decided later on. Possibly that's the view.
No, entire thing will be decided.
Correct.
Whether your exception will be accepted or rejected, and that the other first and second you have accepted in your written notes.
Then
the only thing to be decided upon hearing both parties is whether your ground floor exception will remain or it will go.
Lordship.
And that has to be accepted in
in entirety.
So absolutely. So that has to be decided with the other two floors also. Piecemeal decree again, my lord. It may.
No, question is, you see, when on the next day, when I hear and decide your applications, that is your exception to the report.
Lordship.
Okay. For example, we forget about plaintiff's
Absolutely.
application.
Absolutely.
Suppose I accept your written notes, your submissions, your contentions, that with regard to first and second floor, you have no problem.
Lordship.
Okay.
Lordship.
Just like Justice Mukherjee's
Lordship.
order, that can be allowed.
I
Or
was thinking in that way.
That is that way, keeping that for some
Other point
for
open.
further consideration.
Other point open.
And necessary steps may be taken, or both your
All together.
submission as well as the third point.
I got you.
Either accept it or reject it.
Third has gone, settled. First and second.
First and second,
And
you are
ground.
accepted. You are accepted.
I have accepted.
So either I can decide in piecemeal first, that is first and second, and ground floor after hearing both parties. Either I will allow your prayer or reject your prayer.
I got your point. I have no objection. I have no objection because
so anyway, let this matter be heard out and discussed
Any day,
on,
any day.
on the next day.
That's it.
And the
May I
import-
submit?
Yes.
First submission is that on the 10th June, I have submitted affidavit of reply with affidavit of service that is not been recorded in your Lordship order on 10th June. Kindly record it. Second thing, that already the exception applications taken on the report of the Partition Commissioner, report dated 7th April 2018. It is in respect of the whole property, not only the dwelling house, but also another property at 124B business colony, that is the business lending colony, which is the proprietorship business and the certain rooms. That has not been disposed of. In the exception application 1 to 4, in respect of the 124B Lenin colony, has not been disposed of in GA number 1933. Only the dwelling house at 2 Durgacharan Dr. Lane has been disposed of in respect of the third floor and in respect of the 10% excess area. Because while disposing this application for passing a decree, Justice Mukherjee asked them, they are always objecting that we will stay. We have been staying here for a long time, and we want the southern side, northern side. We have forgot the southern side to him, and he is wanting more areas. We have also forgot in front of the court that is recorded in the Justice Mukherjee's court, and on that basis, the agreement was made that if I over and above the 5% more in the report dated of the Partition Commissioner was that it will be 55% first to the plaintiff in the southern side and 45% to the defendant in the northern side. And they are not agreeing. So in the open court, the court asks that whether you are agreeing to release 5% more. And we decided the matter and agreed that subject to condition that 10% excess will be given from the ground floor. That is recorded in the Justice Mukherjee record in page 3. Kindly go through it. Reply. Kindly go through page.
Page.
Here go the original application. Original application.
কোনটা পড়বেন স্যার ওই 17th অক্টোবর
17.
এই যে স্যার আমি দিয়ে দিই
December 2009. এই যে আমার কাছে আছে। In my original application, page number 4, 3 to 4.
Page number 4,
That
yes.
the Commissioner of Partition is directed to visit and prepare a further report within 2 months from the date of the assistance of the service.
Page 4.
Page 3. It is page 3.
Page 3 of?
3 of my application, original application for decree, GA number.
Page 3. Let me see.
17 running page and order page, inner page is 3. Running page is 17.
এফিডেভিটটা দেখি এই
Original application.
না না GA 9 of 2020
Yes, that
main
application.
petitionটা this is GA 9 of 2000
আমার আর্গুমেন্টটা কোথায় আছে এখানে দেখো। Or written notes and argument.
yes that is page 4
Page 3.
page 3 yes
Running page 17.
yes
Let's kindly go to the last, almost to the
running
bottom
page 17
page 17.
yes
So, in the event, in here, I'm just not going upstairs. The commissioner of partition, the last penultimate part, the commissioner of partition is directed to visit and prepare a further report on the basis of which the report has been submitted by the partition commissioner within 2 months from the date of the assistance of the surveyor as to the other floors. So on this basis, the partition commissioner has submitted his reports by effecting partition by meets and bounds. There was the in GA petition, GA application, the report was not by meets and bounds. This meets and bound was ordered by the Honorable Justice Shiv Prasad, Justice Shivkant Prasad on 7th November 2016, and thereby he directed that partition commissioner will effect the partition as in equal area by effect the partition 50-50 to each. And on that basis, the partition commissioner, taking this advantage of the Justice Mukherjee's report, submitted his report that is on page 10 of the report. Now, kindly, I'm going through it, suggesting
page
that
10 of the report
I'm just completing this note.
yes.
Report within 2 months, plot premises. Rather suggesting the additional allocation to the plaintiff because we have forgot, we have released the 10% in the third plot. So additional, we are getting 10%.
Pursuant to the order passed on 17th December 2019.
Yes.
In which page?
Page number.
That is the second report of the commissioner.
No, this is the final report.
No. Pursuant to the order passed by Justice Mukherjee, was any further inspection carried out and further report submitted?
Further report submitted in respect of the physical delivery of the 45%.
Whatever it is in terms.
That is on the 3rd October 2019.
3rd October 2019. No, this order.
2014. 2024, possibly.
3rd October 2024. Yes, where do I get that?
Yes, I'm showing it. I'm showing it.
Which?
I'm getting it.
No, have you annexed in your reply or petition?
Yes.
Petition accordingly.
Petition according, it is the order of the court.
No, question is that.
No, it is, I have not annexed it.
So these two reports should be before the court, okay? First report.
But order has not been added.
Yes, first report, thereafter, Mr. Dev's application, that is GA 1933. Thereafter, Justice Mukherjee's order. Thereafter, second visit of the commissioner, and thereafter your application. All these 5 things should be placed for necessary decisions.
Not in one place, but it is placed in.
Give it in a compilation, okay? On the next.
That may be, but Lordship, we have, because my prayer was that it is for the propriety of the document, the court should be relied. Why the court will believe on my record? Why the court will believe on the defendant's record or plaintiff's record? Kindly direct the department because all reports.
Please give a compilation, both of you. I'm requesting both of you. Please give a compilation of all these 5 documents. Your written notes is here. Okay.
Yes, my written notes is also. Okay. I'm submitting. Lordship.
Because you see, all these 5 compilation are necessary.
Lordship, my written notes here. Yes. I have compiled it.
Yes. First commissioner's report, thereafter order, thereafter Justice Mukherjee's order.
29.
Second commissioner's report.
Yes.
If you can furnish your copy of this application, it is well and good. That is your GA 1933 because it is pending disposal.
No, I accepting that is it is okay, provided annexure is not given. GA number 133 is okay. And the report dated 7th April 2000, he has submitted, it is okay, except the annexure. So I'm accepting it. No problem. My one thing, my Lordship, I just want to draw your attention. This 10% has been directed by the Honorable Justice Mukherjee to give them from the ground floor. And that report dated, report of the Partition Commissioner on 22nd December 2024 contains that 10% I am giving from the ground floor, but they don't accept. 10% they are agreeing.
Whatever is there, it is binding. That has to be that has to be given.
That is in the record, sir.
Yes. Whatever is there, that has to be given.
That
we cannot deviate from that.
Duto southern side, because they have taken in the report dated 7th April 2017, the same southern side is taken by the defendant in the 3rd floor, and the southern side was given to the plaintiff in the ground floor, and that was the suggestion of the suggestion of the commissioner in the page 23, para 37. That was that time that exception was not taken, and then now we are saying that I will not accept the southern side of the 10%.
Anyway, Mr. Dev has only filed this application. He has not filed any other application, 1933.
No.
Whatever is there.
No, I filed it.
Yes, whatever is there, that has to be decided, either allowed or rejected.
Absolutely. Otherwise, decree can't be passed. Order 26, Rule 16 or 17.
Lordship,
Report
Order 26, Rule 70 is not that thing. What he is saying, preliminary decree has been passed, partition has been effected. So the basis of the passing the degree, only the report of the partition commissioner, provided if the court asks that these documents you submit, that documents are lying because in the court. And we have also filed it on affidavit. So what is the problem of taking those affidavits of my submission?
Learned advocates for the parties are present. Are learned advocates on both GA 9 of 2024 and GA 1933 of 2018. Let the affidavit in reply filed to GA 9 of 2024 be kept with the record. Mr. Dev appearing for the
sole defendant.
For the defendant, files his written notes of arguments with regard to GA 9 of 2024. Let the same be kept with the record.
And I have also filed that notes of argument.
Okay, Mr. Give your name, please.
Sanatan Ghosh.
Yes.
Sanatan Ghosh.
Mr. Sanatan Ghosh, learned advocate appearing for the plaintiff, also files written notes of arguments. Let the same be kept with the record. Let this matter appear on Okay, 14.
That week I told you in the morning I have some difficulty. I will not be after 19th. That week I will not be.
Lordship, I have that difficulties after 10 July.
I'm keeping it on 23rd.
No, I will not be here. Kindly, before that you give it. With you, after 1 week, let it. After no, later. I mean, let me make my submission.
No, 7 to 11 there is uncertainty. Okay, this bench may not sit from 7 to 11.
6th, you please give.
No, 6th is Sunday.
Sunday.
So that is why 15th you have some difficulty after 18th.
That week personal difficulty any day after 18th.
Then I am to appear virtually.
Yes, I have no
problem. 18th.
I stay in Delhi.
Week
I'm practicing in Supreme Court, so I'll virtually appear.
Any day after 19th, any day. In the other
any day you give, I will appear from the Supreme Court.
Supreme Court virtually, sir.
আমাদের চেম্বার আছে.
You'll appear virtually. Your junior will be here.
Here.
To render assistance. And any other further written notes you circulate?
Any other further written notes?
If you think some other decisions is to be cited, okay, learned, let this matter appear on 22/7/2025. learned advocates are requested to give a compilation of the first commissioner's report.
The first commissioner report is vague because there are plethora of reports. First, that is report particular dated. Report dated 7th April 2017. Because on that basis, the exception was taken.
We will
Which
indicate all
report?
All
Yes.
documents.
the report.
Only the
Let
report.
let the reports submitted by the learned commissioner be filed in the compilation
Absolutely.
by the learned advocates along with order.
Justice Mukherjee order, I have
Already I have also annexed.
any subsequent orders and the final report which the commissioner filed after the order of 17th
And
October.
the final report submitted by the learned commissioner pursuant to the
Order
dated 17th December 2019.
90. Yes.
So give a compilation of the report.
You would give, my lord.
The,
All documents, all documents.
the order of Justice Mukherjee and these two applications.
And
These
my
are to
learned
be-
friend referred to another order, all we will
No,
be
that is
produced.
not a question. Question is that first, partitioner receiver, commissioner of partition should be required to be present because we have got no document. I'm saying that you please come and say what documents you have produced before the court. He's saying we have produced every document, but he's not coming.
The report is
Direct the partition commissioner to present on that day.
He is not going to be examined. He is the
No,
commissioner.
yes.
Senior
Report is not available.
No, you do one thing. You
Do
just
the
see, you
compilation.
sit together and see, verify whether both of you have received the entire report
If
or
we
not.
have not, we would request the commissioner of
Learned
partition.
advocates.
He will not
Learned
listen to us.
advocates are granted liberty to intimate the learned commissioner
Yes.
in the event they have not received the entire state of the
Absolutely.
report.
If we have received, my lord, then why should we bother him, my lord?
Received 0.5%.
So you intimate the commissioner if you have not
Absolutely.
received.
Absolutely, my lord, grateful.
Next 22nd July. Grateful level.
22nd.
22nd. Okay.
Yes, Mr. Mitsu, are you ready now?
There are two applications, my lord.
I'm for the plaintiff.
Two applications, why?
I'll tell you, Lordship, my lord, the first application is, my lord, Lordship will find from the cost title that, my lord, the defendant is the board. They are in possession of the property, my lord. The suit is a suit for eviction. Now, whatever happens in the suit, in the meantime, my lord, my client wants to, my lord, or is required to carry out certain, my lord, repairs. Repairs and, my lord, change of, my lord, lift which has become defunct, my lord. They will do it at their own cost, my lord, without claiming any equity. That is, my lord, the first application.
GA16.
GA15. 15.
GA15. And GA16 is for?
GA16 is, my lord, the evidence of the sole witness of the plaintiff was, my lord, closed. My lord, it's, my lord, there is a change of advocate, my lord. After that, my lord, it appears that, my lord, some further cross-examination is required. For leave to, my lord, further cross, that will not take long, my lord.
Yes, have you filed any opposition to this GA5?
I'm for the plaintiff. The two applications just mentioned by my learned senior friend seem very innocuous on the face of it. But let me give you a background of these applications, Lordship. This is an eviction suit. The argument had commenced sometime in 2019. At that juncture, Your Lordship, they had filed an application for adducing evidence after a delay of 13 years. That application was dismissed by the Honorable Single Bench. They went in appeal. The appeal was allowed, Lordship, only on the condition that they pay a sum of 10 lakhs.
So you
which-
contest that application 60.
Lordship, hear me.
No, whatever you submit, you bring it on the records.
Lordship.
On what grounds you are objecting?
Lordship, and the second undertaking, my lord, may I hand over a copy of that order, your lordship, of 23rd December 2024, where they give an undertaking that they would diligently participate in the proceeding and they'll adduce evidence. After that, the matter is there is an endeavor on our part for the matter to be fixed for adducing evidence. That has not unfortunately happened because on the last 3 occasions, they sought time, your lordship. They have come up with 2 applications, which in my humble submission are frivolous. The first of these applications just mentioned about repairs. My lord, they have been in the occupation of the said premises since 1958. Numerous repairs have been done. Permanent structures have been constructed without a consent, without a permission, without us knowing. There have been several repairs in the form of sanitation, electricity. We have photographs. So today coming up and saying that they need to make repairs and they seek leave of this court, it is just a dilatory tactic.
If you do not want to file opposition, I'll conclude the hearing and fix a date for orders in both these applications.
Lordship, and the second application, adduce.
This is 15, you see, 15.
Lordship.
You see, different matters in landlord-tenant suits, orders of repairs are being passed.
Lordship, but
Nothing uncommon.
In the past, Lordship, they have not sought any permission.
It's nothing unnatural.
But
Yes, now 15 you are objecting. Earlier it was not rejected. No such prayer was made earlier or was rejected.
Then, my lord, there was no dispute between the parties. That's the whole difficulty.
The case is pending from 1990. From 1990, you did not carry out the repairs.
Apparently.
Now, with regard to GA16, you are strongly opposing.
Lordship, we are strongly opposing because Order 18, Rule 17 is very clear, Your Lordship, recalling of the witness. It has to be used. It is upon the court, first of all, the Honorable Court, who will decide if at all the plaintiff's witness or anybody's witness has to be recalled, and it has to be used sparingly. And only if there is any doubt with regard to whatever deposition has been made by the witness.
My lord,
and not to
I'm sorry to interrupt, my lord, to cut short the matter, my lord, if they are not, my lord, willing to file any affidavit, kindly fix any day convenient to the court. I shall come and argue, my lord, both the applications.
Whatever you have given, it's sufficient. On that petition, the court can decide.
Lordship,
whatever you have stated in the petition.
Yes, but I really did not come with, my lord, the cases. I shall come any day convenient if they are not filing any affidavit.
Yes, what are your submissions?
Lordship, I would like Your Lordship to come to paragraphs 25 and 26, Lordship, of GA16. Particularly paragraph 26 at page 9, Your Lordship.
25.
Okay.
May I read paragraph 26? However, due to inadvertence and lack of material instruction, the plaintiff's witness, namely Sri Vishnu Narayan Kashyap, were not put certain questions on cross-examination relevant enough for truthful adjudication of the issues framed in the instant suit. Such questions, if not put to the said witness, namely Sri Vishnu Narayan Kashyap, may result in improper adjudication of such issues framed in the instant suit. This is the only ground made out, Your Lordship. The witness action was closed way back in 2010, Your Lordship. Today, after 15 years, they put in one paragraph saying they want to put certain questions which all of a sudden they've rose from their slumber and need to put, and that's why they want to recall my witness, Your Lordship. This is all I'm submitting before Your Lordship.
So, my lord, do I take it that, my lord, they are not filing any affidavit in opposition?
My lord,
my lord, kindly give me, my lord, any day convenient to the court, kindly give me a date. I shall argue this, my lord.
My lord, my submission therefore is, we'll give our opposition, but in the meanwhile, there is no impediment for them to put their witness on the dock and comply with the appeals court order of
Let us
23rd.
see the appeal court.
Yes, lordship.
Annex, the G16, page 31.
It's annexure H, page 31, GA16, your
That
lordship.
he won.
Annexure H, page 31.
Yes.
Your lordship was sitting in the division bench, lordship, and this order was passed.
So,
Yes, on the last occasions, on the submissions of the parties, I decided to take up the matter.
Lordship.
As because none of
We agree.
For consent.
We agree.
both of you agree.
Yes. We agreed.
So you have made the deposit.
yes,
Lordship,
yes.
yes.
We have not withdrawn it.
So this was confined to your
Witness. Absolutely.
Yes.
examination of
Absolutely.
witness. Thereafter, you thought that
It
that
appears,
some
my lord,
witnesses are to be
I
examined.
shall tell
That,
you,
that
Lord,
cross-examination is necessary. Subsequently, you thought
because, my lord, there, as I have said, my lord, there was change of, my lord, the complete set of advocates.
That
I
is
am not-
perhaps true.
anyway, so
Lordship,
let
because-
me decide these applications, so pass orders on these two applications.
Lordship, we'll file a opposition, but in the meanwhile, Lordship will direct them to call their witness on dock, Lordship, because there is
How
no.
soon can you file your opposition? In both the applications or only this
Both
thing?
the applications.
Both the applications. Anyway, they have complied the court's order. That is, they have
Lordship, but-
deposited that amount.
Lordship will kindly see this is nothing but dilatory tactics on their part.
Then, my lord, they should not file affidavit, I would say.
Yes, record an order.
Okay, Nischinto to.
Mr. Mitra, learned counsel for the defendant petitioner and learned and MS Madhupriya, learned advocate appearing for the plaintiff. Opposite parties are present. Both applications GA 15 of 2025 and GA 16 of 2025 are moved and hard stop as learned advocate for the plaintiff prays for time to prays for leave to file affidavit to both the applications.
My lord.
Yes.
Kindly pass, my lord. My instruction is kindly pass two separate orders. Maybe the identical order, but in two GA.
ওটাকে দুটো আলাদা করে দিন, হ্যাঁ আলাদা, তাহলে GA 15 এ একটা অর্ডার করে দিন, হ্যাঁ learned GA 15 এ একটা করুন, learned advocate for the parties are present. GA 15 of 2025 is moved, stop, as learned advocate for the plaintiff intends to use an affidavit to GA 15 of 2025. Liberty is granted to file the said affidavits on or before 11/7/2025. On or before 11/7/2025.
Yes.
Reply, if any,
7 days, my lord.
on or before 19/7/2025. 19th, after all, is a working Saturday, so you can file it on 19th also. Let this matter appear on 23/7/2025 within first 10 matters. আলাদা আলাদা the defendant is at liberty to examine the witnesses on the next date fixed
Their witness, your lordship.
Yes, yes, the defendant is granted liberty.
To-
You are granted liberty. You may use it to examine their witness on the next date fixed.
Without examining their witness, my lord, the further.
Lordship.
I shall tell your lordship, my lord, your lordship knows, my lord, about suits. My lord, I have to
আচ্ছা একে কেটে দিন ওটা
I
লিবার্টি
have
ওটা
to
কেটে
put
দিন
questions, my lord, which I have to, my lord, put in cross-examination. So their witness would know my case.
Okay.
Lordship, they have already submitted their documents. Lordship will kindly not allow that. Let them produce their witness on the next occasion.
Okay, the matter will appear on 23/7/2025 within first 10 matters.
Lordship will
These
record my
দুটোতে
submission.
same order.
Lordship will kindly record my submission that I'm objecting not to produce their witness on the next occasion. Because this is what my
Although learned advocate for the plaintiff submits that the witnesses be produced by the defendant on the next date fixed, but as prayed for by Mr. Mitra, learned counsel appearing for the defendant, in the interest of justice, the defendant is granted opportunity first to cross-examine the witness of the plaintiff.
And
Mr. Mitra is granted opportunity to defer the examination of his witnesses till this application is disposed.
Lordship, one more thing. Last order, Lordship, 17 June 2025. There's an by mistake the cost title has gone as Anirudh Sinha as well. West Bengal Board of Secretaries. That has to be.
Oh, you are a defendant.
Just
No, I
Anirudh
think I
Sinha
have
has
to.
to be.
Okay. In the cost title of the order dated 17 June 2025, by mistake, it is recorded as Aniruddha Sinha.
উপরে নিচে সব জায়গায় না
Let a necessary rectification be made by deleting the name Aniruddha Sinha from the cost title.
Item number 35 and 36.
35 and 36, my lord, I am for the plaintiff, my lord. My application GA4 of 2025, my lord.
I'm strongly opposing. I'll file my affidavit in opposition.
Is it a
Kindly give us 3 weeks, my lord.
It is a substitution application, my
No,
lord.
my
The
lord.
plaintiff
For
number one
the
has
last
that.
2 years, they have been doing this. For the last 2 years, they have been taking time. Every time they come and
You are appearing for?
I'm appearing for the respondent in both the matters, my lord.
That means defendants.
Defendants.
They have also a suit.
My
In
lord,
their suit also,
that-
they have to take a substitution application. They have not taken out any substitution application. Now they are raising voice as if I am the only culprit here. It has the death certificate has also been provided to the defendants.
GA4.
GA4. Now, my lord, other than these two suits, there is a suit pending of the defendants that has been filed by them. And in that suit also, I have the plaintiff number one is a party, and there has to be a substitution application has to be taken out by them.
GA3 is whose application? GA3 of 2021?
GA3 is probably our application
Your application for
injunction.
Okay, anyway.
Interim relief, my lord.
And GA4 is your
GA4 is substitution application that has to be moved first.
Okay, and the GA4 of CS67 is also
substitution application.
Yes,
I'm strongly opposing, my lord. I'll file my opposition.
Very well. Fine.
Kindly give us 3 weeks time, lordship.
3 weeks
opposition.
Opposition 3 weeks. Substitution application.
Too much time is required. No questions of law is involved.
2 weeks, lordship.
Yes. Learned advocate. দুটোতে আলাদা অর্ডার করে দেবেন হ্যাঁ learned advocate for the parties are present. You are representing all the plaintiffs. GA4 of 2025 is taken up for consideration. Learned advocate for the defendant intends to use an affidavit in opposition to the said application. Thus, liberty is granted to file the affidavit in opposition on or before 15/7/2025, reply if any by 21/7/2025. Let this matter appear on 22/7/2025 under the heading adjourn motion.
Deeply obliged, my lord.
Yes,
Gratefully, Lordship.
36 also same order.
36.
Yes, same order.
Analogous matter, Lordship.
Yes, yes, separate orders will be recorded.
Deeply
35, 36, same order.
Lordship, I appear on behalf of the plaintiff. Lordship takes up its order. The last order dated 18th
Yes,
June
yes.
2025.
Yes, learned
Lordship, it
counsel
asks-
for the official liquidator is present today.
Yes, and Lordship, I am seeking one more indulgence. The affidavit of service
May I
of the
hand over
direction.
a copy of this order by which, my lord, the entire liquidation proceeding was transferred to the NCLT, and my lord, the official liquidator has already been discharged.
Yes, yes. Now the question is, so this suit was against, so in this particular suit, no, this is so far,
My lord, the company CP number 742 by which the winding up order was passed. That proceeding was transferred to the NCLT.
yes,
And
why
my lord,
is
the official liquidator was discharged
by this court.
by this court.
As
My lord, that
because
is
as because that winding up proceedings was transferred.
yes, my lord.
So it is an admitted position that there is a winding up proceedings against the defendant.
Yes, my lord.
This is an admitted position. So if there is a winding up proceedings, so there is no scope to proceed with this suit.
Your Lordship will give me the right to proceed according to law, and your Lordship will protect the
Yes,
litigation.
my lord, your lordship kindly grant them leave to proceed this suit before the company court.
Yes, your Lordship.
Only, my lord, under section 446 of the Companies Act, the company court has got the jurisdiction to entertain any suit either against the company or by the company. My lord, if you, I do not have immediately, my lord, this
Now
section.
the question is, this was a simpliciter suit, okay?
Yes, yes.
And by
No, if it is against the company in liquidation, then, my lord, this jurisdiction should be, my lord, before the company court.
company court means
Company court means, my lord, the court, my lord, which is having
having the
jurisdiction-
determination.
determination of the company court, my lord. Presently, Justice Sugata Mujumdar is in, since, my lord, Justice Krishna Rao is not here. So otherwise, Justice Krishna Rao was the jurisdiction, my lord.
That means
The
when the
company-
company goes into liquidation,
Yes, then entire suit proceedings against the company or by the company will
that means
transfer
the
to
matter has to be released from this court
Yes.
and be
to
and
the
liberty should be
determination of the
granted
company court.
to place the matter before
Before
the
the company court.
court having determination
Yes.
to take up company matter.
Yes, yes, my lord.
That liberty has to be granted.
My lord, my lord.
Yes,
But
record an
they-
order.
One more indulgence, Lordship, I'm praying for. There was a direction upon me to file an affidavit of service, which I have not been able to do since my learned friend is
Anyway, I'm recording
kindly
Mr. Chaudhary's
waives that.
presence.
Kindly removes that. The direction for me to file an affidavit of service.
Okay, learned advocate for the plaintiff is present. Mr. Chaudhary, learned advocate for the official liquidator, appears and submits that the defendant company SRC Udyog Limited has gone into liquidation and by order dated 30th January 2025, passed by a learned single judge of this court, the winding up proceedings are transferred to National Company Law Tribunal, Kolkata. Stop. In the facts and circumstances, this court has no determination to adjudicate this suit. Thus, this suit stands released from this court and liberty is granted to the plaintiff to mention the matter before the learned company court having determination.
But the suit against the company in liquidation. Kindly mention this because your lordship has
As
got
because
jurisdiction.
আচ্ছা ওই আরেকবার পড়ুন তো ওই জায়গাটা কি আছে তার আগের সেন্টেন্সটা suit against a company,
in liquidation.
a company which has gone into liquidation.
Yes.
Thus, তারপর যা আছে ঠিক আছে, matter stands released, let the matter, plain parties are granted liberty to mention the matter before the bench taking up company matters.
My lordship kindly discharges the filing of the affidavit of service.
The affidavit of service, filing of affidavit of service is dispensed with.
Grateful. I'm deeply blessed. তোমাদের চিঠিতেই তো কপির অর্ডারটা ছিল। ওটা না, ওটা না, এই যে এই দেখো।
Item number
এই পাঠিয়েছি।
38.
ওটা না, ওটা ছিল।
38. Yes, not today.
Grateful.
Replacement action, item number 40.
My lord, I appear on behalf of the plaintiff. My lord, I am appearing for the defendant. My lord, suit for eviction. My lord, on instruction, I am submitting. I'm sure my learned senior friend will also support. The parties are in talks of settlement.
So let it go to mediation. Okay, it would be better. Okay, I'm giving 5 weeks times or 6 weeks times. In the meantime, you
My lord,
settle.
what little I know, I'm just indicating that thereafter what my lord decides.
Yes.
The parties are in talks amongst each other in presence of the both advocate on records or whatever. If whatever falls from my lord, if the matter can be taken up after 3 weeks or so, thereafter my lord may.
Sometimes you see,
yes, my lord,
these bipartite settlements do not work. Sometimes, but if it is before the mediator,
channeled.
Yes, if there is a mediator, bipartite talks sometimes fail. But if there is a mediator, it can succeed.
Let us try in this way, my lord.
Because you see, this is not a heavy,
Absolutely.
this will not incur huge costs like arbitration.
In that event, subject
Yes.
to what my lord says, can it be there tomorrow as to be mentioned? I shall take instruction and accordingly, my lord.
Then let it be day after tomorrow.
Day after tomorrow, my lord. It will be easier
let
for
this
me.
Matter appeared. Okay, let it be not today and tomorrow. Day after tomorrow has to be mentioned.
Yes, because otherwise, what has fallen from my lord is absolutely right. In the event, perhaps this doesn't work out.
Because mediators can suggest
If
some
it is
terms.
channelized, perhaps the settlement talks would be in a more concrete fashion.
That is why you see so many complicated matters. Mediators are appointed. And it is also not very expensive like arbitration.
My lord.
Anyway, let it appear on?
Day after tomorrow.
Yes. 3/7/2025.
My lord.
Under the heading to be mentioned.
I appear for the plaintiff. Initially, there was a recent notice was directed to be served upon the defendant since they were non-appearing. One of such notices came back as deceased. Currently, my lord, we have no idea whether the defendant is at all alive or not, since no one is appearing on the.
So if you
no,
any report has come.
No, there's no report. On the last occasion, my lord, we sent a letter to the legal heirs since there are several proceedings pending with regard to this company. They are the legal heirs of the defendants are parties.
So far, this original defendant is concerned, it has returned with what remarks?
One of them returned with the remark addressee cannot be located. The other came back with the remark deceased. Now, my lord Justice Patnaik directed us to get a report before the local municipality whether there is a death certificate issued or not. We did that. There was no death certificate. Those are filed by way of affidavit of service and kept with the record. At this current moment, there is no conclusive proof whether she is alive or not.
One thing you can do is paper publication was
we
made.
have done. That was also directed. We have done. After that, my lord had directed, Justice Patnaik had directed the suit to be heard ex parte. That is why it is appearing as undefended suit. There was an application for recalling which was allowed. Subsequently, when I pointed out to your lordship that there's a postal consignment with the remark deceased, my lord had directed us to take necessary steps. The steps we had taken, we had tried to communicate with the legal heirs, and all the postal consignments came back as left. The son, only son and only daughter admitted of the defendant. That came back as left. Right now, we have no conclusive update regarding whether she is at all alive or not.
This is a suit for eviction.
No, suit for declaration that I'm the plaintiff. I prayed for declaration that I am the rightful heir of my father, and she claims to be the rightful heir of that my father as well. The suit was filed with the Shialda court. It was transferred here. They filed a counterclaim that was decreed in my absence, since I didn't know regarding the transfer of the suit. I filed an application in 2011 for Order 9 Rule 13 setting aside.
That was allowed.
That was allowed in 2024, 5th of January. Previous to that suit has been running undefended. Right now,
Regarding municipal authority, what did they say? Any death certificate?
there was an RTI. RTI reply came back as there is nothing as such. That is filed before your lordship by of every bit of service. I'll have to check up the record, but that is there in the record. Well, Mr. Dev, who was appearing in item number 32, was appointed as a receiver by Justice Banerjee, as his lordship was
Item 30?
Item 32, Mr. Shudip Dev.
Yes.
He was appointed as a receiver by Justice Banerjee, Sanjeev Banerjee's order, as his lordship was then, my lord, in 2015. These matters are long-standing matters. He is still the appointed receiver of the property, and he still holds the
Which
property.
matter? Which matter?
This he was appearing item 32. I informed him, my lord. This is not connected to that. Item 32 is not connected.
41, Mr. Dev was the receiver of 40.
Receiver not with regard to this suit. There are several other company matters pending with regard to Mountain Equipments. The shares of Mountain Equipments are the subject property. He has been appointed as a receiver. He continues to be appointed. Still, he's the receiver. I can file an application for the receiver to represent the estate of the defendant in our absence.
No, question is, you see, but so far this suit is concerned.
I'm in a limbo. But I don't know whether to take out an application for substitution without any death certificate. Because it's still inconclusive.
Or I can appoint a special officer to inquire as to whether
my lord does that.
Whether this person is still alive or
Promit Roy was appearing on behalf of the defendant much back, my lord. We say SS Roy and SC Roy Chaudhary and associates were appearing on behalf of the defendant. I have inquired from them. They are refusing to at all acknowledge the letters were sent to them. And at this junction, I'm praying for necessary orders to be passed.
Learned advocate for the plaintiff is present. It is submitted by the learned advocate for the plaintiff that in this matter, nobody is representing the defendants for a long time, for which service was caused upon the defendants. Stop.
Defendant, only one.
Yes?
Only one defendant.
It is further submitted that paper publication was also made and there is no response till today. Learned advocate further draws attention to the registered envelope which was sent to the defendant but has returned with the remark deceased. In spite of making inquiries before the municipal authority, the plaintiff could not ascertain with regard to the death of the defendant, although the registered envelope returned with the remark deceased. In the facts and circumstances, this court is of the view that a special officer should be appointed to ascertain as to whether the defendant FIONA ANGWELA ROY within bracket DAS dash, ঠিক আছে, alias ALIAS FIONA ANGELA MORIS DAS dash is still alive or not. Stop. In the event the said defendant is not alive, the learned special officer shall ascertain as to who are the legal heirs of the said defendant. Dash is appointed as the special officer. Learned special officer shall cause the inquiry and submit a report on or before 28/7/2025. Let this matter appear on 30th July 2025 at 4 p.m.
I'm extremely grateful, my lord. I'll be very candid, my lord. There's the issue with regard to the remuneration that will be fixed on that day.
No, I shall fix the remuneration. I have not
On
yet
the-
decided. The name and the remuneration, I shall
Very
mention.
well, very well.
You
very
see it in the order.
Very well, my lord. I'm grateful. I'm grateful, my lord.
And hand over the relevant documents, yes, the parties, the plaintiff shall hand over all the relevant documents to the special officer.
Very well. I'm grateful, my lord.
Order number 42.
Yeah, I approve the plaintiff.
Mr. Somnath Gangopadhyay is appearing on behalf of the defendant number 1, my lord. He's
But virtually,
No. He's admitted in hospital, my lord. I'm only praying.
so suggested issues are prepared by you.
We have prepared our suggested issues.
Anyway, let them get some time.
Yes.
May I file my suggested
Yes,
issues?
yes. Learned advocate for the plaintiff is present and has filed the suggested issues. Let it be kept with the record. Learned advocate for the prayer for time is sought for on behalf of learned advocate for the defendant on the ground of his hospitalization. Let the
I am for the respondent 2.
he's
Defendant number
one,
1.
I am
okay. Prayer for time is sought for on behalf of learned advocate for defendant number 1 on the account of his hospitalization. Learned advocate for defendant number 2 is also present. Have you filed your suggested issues? But have not filed the suggested issues. Thus, this matter stands adjourned till 16/7/2025. The defendants shall prepare the suggested issues in the meantime.
One indulgence, my lord.
Yes.
Item number 40, the matter which my lord was pleased to observe that it might go to mediation for
Yes,
better
yes, yes.
result. I just took instruction. My client is out of town. Can it be on Monday instead of day after tomorrow? I will inform my learned senior friend.
Very well. Monday there is some uncertainty. Acha, item 40.
Item 40.
আচ্ছা আইটেম 40 তে একটা রেকর্ড করে নিন তো হ্যাঁ ওটাকে কেটে দিন আর কি item 40 on the prayer of the learned advocates the matter stands adjourned till 15/7/2025.
He is unavailable this week, so it will be better for us
Next
to.
week there is some
Very well, my
uncertainty.
lord. Very well, my lord. 16/7.
15/7.
15/7. Grateful. To be mentioned, date.
এটা আপলোড হয়েছে হ্যাঁ এই তাহলে টু বি মেনশনডে দিয়ে দিন এই হ্যাঁ না এটা আপলোড করেছেন তো আপলোড যখন করেছেন তো এটা বেটার ইয়ে করে দিন ওই বৃহস্পতিবারে টু বি মেনশন না এখানে না সার্ভারে কোনটা দিয়েছেন 2000 হ্যাঁ এটা সার্ভার করেছেন বৃহস্পতিবারে এমনি বেঞ্চ থাকবে কিন্তু অ্যাপেলেট সাইড আর নেওয়া যাবে না অ্যাপেলেট সাইড সেই 18 তারিখ তাহলে বৃহস্পতিবারে করে দিন বৃহস্পতিবারে ওই বৃহস্পতিবারে সময় কিংবা 10:30টাতেই একদম না বৃহস্পতিবারে তাহলে 1টার সময় রেখে দিন ওটা কি টু বি মেনশনডে আসবে কারণ ওই তারপরে সপ্তাহে একটু আনসার্টেনটি আছে তো ঠিক আছে ওই তাহলে 4টের সময় করে দিন আর যদি হলো যদি 3:30 হয়ে যায় হয়ে গেল পরে অন্য ডেটে করতে হবে আর কি টু বি মেনশন তাহলে ইয়ে করে দিন ওই হ্যাঁ যদি 3:30-3:30-র মধ্যে যদি হয়ে যায় তো ভালো আর কি আদারওয়াইজ করে দিন ছেড়ে দিন ওটাকে ইয়েতে থাক ওই মানে 2টোর সময় থাক আর কি 2টোর সময় থাক টু বি মেনশনডে হুম 2টোর সময় ঠিক আছে, আমার আবার ডিভিশন বেঞ্চ আছে দুটো, এনিওয়ে ডিভিশন বেঞ্চটা করে এসে করতে হবে। ও আমি আবার রেখেছি, আচ্ছা কি দুটোর সময় রাখি, যাকে থাকলে পরে ওটা অ্যাডজার্ন করতে হবে আর কি। আমি তো এখনো পর্যন্ত অ্যাসাইনমেন্ট আছে আর ফার্দার রাখবো না আর কি।
आप कहाँ जा रहे हैं? कहाँ जा रहे हैं? ये ले लीजिए ना पहले, ये एक तो चिट्ठी है। अरे एक तो चिट्ठी वो इधर उधर हो जाएगी, देना है तो दीदी को दीजिए। तब ओ ठीक है, लिस्ट का है, लिस्ट का है।
আরে অর্ডারটা শতম মানে যেখানে ছিল না তো, আমি এর মধ্যে 8/17 আজকেই 26/6, হ্যাঁ 26/6 একটা করেছিল তো। আচ্ছা এখানেই থাকবে, ওটা যাবে, এটা ভুল করে ছিল। যে 1/24 শুট নাম্বার 1004/69। হ্যাঁ আমাদের কোটে তো অজয়লাল আচার্য, আমি তো নামটা দেখেই তো রিসিভ করেছি, দুটোতেই অজয়লাল আচার্য লিখে দিয়েছে। হ্যাঁ আরে রিসিভ করেছে, এখানেই আছে, নয়তো সঞ্জয়ের কাছে দিয়েছি, তাহলে সঞ্জয় হয়তো ফাইলে বুঝেছি, बाद में देखेंगे, खाता रखे यही। अरे मैं काम में ही जा रहा हूँ, मैं क्या उधर उधर टहलने जा रहा हूँ।